Welcome to the Appellate Division First Department. The court is now in session. My name is Rolando Acosta, and I'll be presiding with panel members, Justices Renwick, Justice Singh, and Justice Moulton. I will begin with a call of the calendar. People versus James Casey is submitted. Elango Medical versus Trump Palace. Appellant Trump Palace has been given 3 minutes and one in rebuttal. Elango Medical gets 3 minutes. RN Children is submitted. Elkane versus Lotte New York Palace in City of New York. Appellant Elkane gets 6 minutes and 2 in rebuttal. Respondents Lotte New York Palace and City of New York get 5 minutes each. Hammond versus Equinox Handling. Appellant Hammond gets 3 minutes. Equinox Holding is submitted. People versus Summa is submitted. Feinberg versus Marathon Patent. Appellant Feinberg gets 7 minutes and 2 in rebuttal. Respondent Marathon Patent gets 7 minutes. Respondent Nutel gets 7 minutes. Chen versus Lockett. Appellant Chen gets 5 minutes and 1 in rebuttal. Lockett gets 5 minutes. Subillaga versus Finley Teller. I understand that an application has been made and the court has granted it. That matter is adjourned to, well, the parties will be notified. It will be adjourned probably to the next term. 191 Realty versus Tejeda. Appellant Tejeda gets 6 minutes and 2 in rebuttal. 191 Realty gets 6 minutes. People versus Ronnie Johnson. Appellant Johnson is given 4 minutes and 1 in rebuttal. The people get 4 minutes. Jane Doe versus Bronx Preparatory. Appellant Bronx gets 5 minutes and 2 in rebuttal. Jane Doe gets 5 minutes. Karen MD versus Raju MD. Appellant Kareem gets 6 minutes and 1 in rebuttal. Raju MD gets 6 minutes. Solakaya versus City of New York. Appellant Solakaya gets 4 minutes and 2 in rebuttal. City of New York gets 5 minutes. All Republic versus Con Edison. Appellant All Republic gets 5 minutes and 1 in rebuttal. Con Edison gets 5 minutes. People versus Wellington Fulmore Salvador. Fulmore Salvador appellant gets 5 minutes and 1 in rebuttal. The people get 5 minutes. Isa Realty versus Lamar Advertising. Lamar gets appellant gets 6 minutes and 2 in rebuttal. Isa Realty gets 6 minutes. Rodriguez versus City of New York is submitted. Bootcamp versus Board of Standards. Barry's Bootcamp appellant gets 5 minutes and 2 in rebuttal. Board of Standards and Appeals gets 6 minutes. Prinky Pass LLC versus Charleston Tenant is submitted. Liparulo versus New York City Health and Hospitals is submitted. First case for argument is Elango Medical versus Trump Palace.
Good afternoon, Your Honors. I'm Magda Cruz of the firm Belkin Burden Goldman LLP. Can you hear me well?
We can hear you, Ms. Cruz.
Thank you. I represent the managing agent, Trump Corporation, of the condominium at Bar. The managing agent in this case simply acted at all times within the scope of its representative responsibilities on behalf of the condominium board, a disclosed principle in processing a unit owner's lease application. The managing agent has no—
Judge Singh, isn't it
Yes.
the policy of Trump Corporation to require color photos as part of the application process?
The form that is given to unit owners, which is in the record at page 227, does have that item as one of the
I
items.
wonder, what's the basis for that requirement? And in this instance, was that procedure followed?
I don't know exactly the basis for that requirement. And in this case, it appears that that color photo was not part of the application that was actually submitted to the board. That application appears at page 70, and you can peruse that document, and it does not contain the color photos, and it also does not contain perhaps other items on that list. So that list is a simple information, a list of for informational purposes to the unit owners, and generally most of the documents are supplied. In this case,
it's your position that the corporation did not know the race of the applicant. Is that correct?
That's correct, Your Honor.
Okay.
And we have an affidavit to that effect, an affidavit that was never rebutted by Dr. Alango herself. Dr. Alango, in response to my client's motion for summary judgment, did not submit an affidavit. In addition, even if the court were to look at the verified complaint in the record—
And that's what I was going to ask you. In the verified complaint, doesn't the applicant assert that her race was known?
Yes, she says that she is African American, but she does not say that she ever had any direct one-on-one communication with anyone at the corporation. And she also does not say that she submitted a photo ID as part of her application. That statement—
Why is the fact that this is Justice Acosta, Ms. Cruz? Why
Yes.
does the fact that it was not submitted relevant in as much as it was required?
The only reason it is relevant is because the attorney for the plaintiffs here brings it up when we submitted the affidavit of our client saying that the board nor the corporation knew of the applicant's race. The attorney for the applicant indicated that there is this informational sheet that is given to unit owners that would have had her photo as part of the application. But
Ms. Cruz,
he did not submit
Cruz,
the photo.
I'm sorry, your time is running out, and I wanted to ask you a question with respect to, because you spent a great deal of your brief talking about the fact that Trump is a agent for disclosed principle.
Yes, sir.
But isn't it a fact that an agent for disclosed principle can be liable for separate wrongful act like discrimination?
Absolutely, that is the case. But
so why should we grant summary judgment on that basis if discovery is not completed?
Because there first has to be a showing that there was a tort committed here. At the very least, there should be a triable issue of fact.
Well, let me jump in there for a second, and I go back to the issue with respect to the photograph. It's the corporation's procedure for leasing condominiums that requires the photograph. Doesn't that suggest maybe discovery should be had in this case to make the determinations that whether or not Trump Corporation committed a wrongful act?
No, Your Honor, because there's the reason why the application was denied was because the proposed commercial use is not allowed for that space.
I understand that's your position, but there seems to be evidence that in for prior tenants, a non-conforming use was permitted. Now, I don't know if those folks were white or black, but aren't those all kind of issues that should be fleshed out in discovery?
Not on this record, Your Honor. And the reason is that at the very minimum, once we came forward with a prima facie case that there was no knowledge even of the applicant's race in this case, that the applicant, it was incumbent upon her to say, wait a minute, I submitted a photo. She did not even do that. In fact, that is not necessarily a requirement. It could or could not have been put in the application. We put in the complete application that was given to us. That is in the record. I believe it begins at page 7.
But you denied the application based on the fact that this was not a professional office, when in fact that very same space had been, at least that's what plaintiff alleges in paragraph 46 of their complaint, that this was a medical office since at least 1993. But I'll let you respond to that as part of your rebuttal. We've gone way over in the first case.
I thank you for indulging me and able to answer your questions.
Thank you, Ms. Cruz. Let's hear from the respondent.
Thank you, Justice Acosta. Thank you, Justices. Just a brief part of this rebuttal has to do with the fact that the movants and the appellants made their motion on July 19th of 2019. The order came out on December 23rd, 2019, but about 2 to 3 weeks before that, there was a disclosure from Corcoran and Garland that had the complete submission. And the complete submission had a color photo of her passport. It had a color photo of her driver's license.
So I'm sorry, counsel, was that submission made to Corcoran or was that made to Trump Corporation?
We don't know. We don't know. All we know is that packet was submitted as part of a response that to a demand that we made to Corcoran and Garland, and presumably because it was 2 color photo IDs, it was transmitted to the Trump Corporation. We pointed that fact out to Ms. Cruz, and I'm happy to say that she reserved some time for a rebuttal, not to be presumptuous, but they are aware that these photos are part of a discovery response, although it did not make it into the record because of the premature nature of their motion. This exists in reality,
so
and they
why,
know that.
You know, Ms. Cruz makes a good point here. You don't have an affidavit from your client. Why is that? Wouldn't your client have clarified all these issues, photographs, et cetera, who the application was submitted to?
Well, we believe that they didn't even make out a prima facie case. They didn't submit an affidavit from the person who was intimately involved with these negotiations, with everything that happened with respect to the submission of the lease.
You say Mr. Lesnick is not someone with personal knowledge, that it was you spend some time in your brief going over that.
That is correct, and we know that from the first paragraph of her affidavit, where it says that she is the Vice President of Property Administration for the Trump Corporation, the disclosed managing agent for its principal, the Board of Managers of Trump Palace Corp condominium.
But your client was only dealing with Ms. Budlong?
My client, through her agents, were only dealing with Ms. Budlong. And we cite in our brief the numerous instances where Ms. Budlong's name appears in the record.
Okay. Any other questions from the panel? Okay. Thank you, Mr. Buzzin.
Thank you, Justice.
May I proceed now?
You may, Ms. Cruz.
Thank you. I'd like to just quickly respond to your question about the prior use. of the unit for a physician's office or medical offices. There appears to have been use of that nature that was not authorized. My client's affidavit indicated, if I believe it is at page 45, 44, yes, page 44 of the record, in which there was a denial that that use was ever approved. The unit owner may or may not have requested a waiver of the right of first refusal. And the other commercial use, again, not proper commercial use, was perhaps home occupation, psychiatric office. So in any event, Your Honor, quickly, the fact that there may have been two other units or even this unit that had been used against the certificate of occupancy.
So you're saying you had no knowledge that those offices were being used for medical purposes, although they are in one floor. I mean, talking about 57-story building, Unit 1C is in the first floor, right?
Yeah.
So
yeah, but no,
you have door people there and guards.
Yeah, no. We're not saying that we did not have knowledge. We are saying that it was not authorized. That's what we're saying. And as to one of the other ones, it was possibly a home occupation use. It was a person that we believe lived there and used a space in that apartment for psychiatric counseling.
Justice, Ms. Cruz, Justice Moulton has a question.
Also, wasn't the unit in a townhouse adjacent to the high-rise? So it presumed did not have a doorman in front of it, right? It was a townhouse.
It was, but we're not saying that we were not aware. We are simply saying it was not authorized. And secondly, we're saying that even
what was the duration of that tenancy? Wasn't it 1993 to 2017? That's a very long time.
Yes, it was a very long time, Your Honor. But simply because that unit owner operated a medical office in his space without authorization doesn't require the board to now, in the present, when a new application is made, to say, okay, you can continue to violate the certificate of occupancy, the condominium declaration, the bylaws, and everything.
Ms. Cruz, let's assume, Ms. Cruz, and there's been no discovery, but let's assume that the prior use was by a white doctor, a white male doctor. Would that have some influence in terms of the board, the agent, allowing that use for decades, and now when it comes to a black applicant saying, sorry, it's a non-conforming use, would that suggest there could be an inference of discrimination, maybe?
No, Your Honor, because the fact is the use is not legal. And under the human rights law, if there is an entitlement by the person accused of the discriminatory act to, in fact, preclude the use, terminate the individual. There's innumerable cases that discuss this. That does not make it a discriminatory act. It is, in fact, and it doesn't matter of the race of the complainant. The complainant can be within a protected class, but if the decision of the accused is a lawful decision, meaning that it is not pretextual.
Well, Ms. Cruz, I'm not aware of those cases because it seems to me that if you choose to enforce the law when it comes to white applicants and you don't with respect to African-American women, that's a differential treatment on the basis of race or perhaps gender. So that would raise an inference of discrimination, and that's what we're talking about. It's just an inference of discrimination.
But there's nothing to make that inference in this record, Your Honor. We don't even know what the race is of the people that
you do have a photo. You do have a photo. You do require a photo, which is unclear to me why a color photo is necessary for you to determine the viability of the applicant.
But Your Honor, we did not have a photo at the time of the application. It is not in the record, and this court, the parties and counsel are restricted to this record. And the fact that
you move very quickly for summary judgment. So you didn't give folks a great deal of time to engage in discovery or do anything else. So
yes, but Your Honor, there's not even a suggestion that that package that was revealed today to me, because I never saw it until today, by the broker, in fact, was given to my client. I have submitted to the court in the record the application that was submitted to my client. That is what controls here, Your Honor. And I respectfully request that there is no basis on this record for there to find that my client has potential liability for a discriminatory act, and we respectfully ask that the lower court be reversed on that point.
Thank you, Ms. Cruz.
Thank you so
much. Next case for argument is El Caim.
May I proceed, Your Honor?
You may.
Good afternoon. My name is Lauren Bryant, and I represent the appellant, Ms. El Caim, in this case. I respectfully ask that the order dismissing the complaint should be reversed because the interests of justice strongly militate in favor of having this case involving the unlawful eviction and arrest of a 75-year-old cancer patient from her hotel room.
Why did it take 18 months to serve the complaint?
Your Honor, this is a textbook case of law office failure, which is a permitted reasonable excuse under CPLR 2005, which was where the motion court erred in this case. And I'd like to point out that it's not simply just that 18 months went by with no word from the plaintiff. So just 2 or 3 short months after the incident occurred, the plaintiff filed several notices of claim with the city comptroller detailing in great detail the happening of the accident over multiple pages. Shortly within a 1-year time span of the incident, filed a summons with notice against the hotel detailing the incident, and shortly thereafter filed a supplemental summons with notice as to both defendants, alleging the exact causes of action that were ultimately alleged in the verified complaint.
Counsel, the question is why you say law office failure caused the delay. It's not clear to me if that's correct, because I think in your papers you say paralegal left and things were not properly marked. But isn't it a fact that for months before that, there were several months before that, the complaint should have been filed? No?
Yes, Your Honor.
So how is that prior to the paralegal leaving? How is there law office failure?
The paralegal herself failed to calendar the complaint, and when she left the law firm, she never let the attorneys know the status of the case. So
she left 6-7 months before, right? Or the delay was 6 or 7 months before the paralegal left. So I don't understand why that was the reason. You had 7 more months to figure out whatever happened with that case. Why, nobody was looking at the file?
Be that as it may, Your Honor, that still constitutes law office failure because it was a failure of the handling attorney and the paralegal to calendar the case. And the handling attorney claims it was on the paralegal to calendar it, that he did see the notices of appearance, discussed it with the paralegal. It was never calendared. I believe the notices of appearance were served.
What about the 2 demands for the complaint that were submitted? I mean, that's really part of the problem, right? I get it. You didn't calendar it. You forgot to calendar it. Unless you alert it somehow, it'll just go by the wayside, right? But you got 2 notices. You need to file that complaint.
Absolutely, Your Honor, and we do concede that we received the notices, that they were discussed with the calendaring department, and that we being trial counsel, that they were discussed with the paralegal and that she failed to calendar them. However, again, I would stress that this is law office failure. It's an isolated incident, and that just as recently as 2 weeks ago, this court held in Fawn 2nd Avenue LLC versus First American Title Insurance that law office failure constitutes a reasonable excuse for default under CPLR 200.
I do not quibble.
Reasonable excuse is where you falter. The question is, what about this was reasonable? That's the problem when you have such a long delay, and then you have another long delay, and there's not an adequate explanation for it.
The adequate explanation was provided in respectfully, Your Honor, in the handling attorney's affidavit, wherein he explained in great detail what happened, which was that he received the notices of appearance and that they were failed to be calendared. And we cited numerous cases in our brief where that in and of itself is enough to constitute law office failure. Law office failure equals a reasonable excuse.
In 18 months? In an 18-month period?
I would argue
where the first cause was the paralegal, and now there are other excuses that don't quite explain why that wasn't followed up. And then there are the two notices. I mean, it just the two demands. It just, when you put that all together, I don't see how you can continue to say that that was reasonable.
I think we have to look at the overall circumstances of this case. So the fact that it failed to be calendared after the notices were served is, I think, where the issue is falling, because once the notices for the complaint were served, that's when the law office failure started. But certainly there's been no prejudice to the defendants in this case, as they had notice well in advance, within 1 year of the happening of the accident. And there's a strong. Did Your Honors have any questions with respect to the meritorious causes of action?
I think we're good. I mean, you may want to raise them as part of your rebuttal.
Yes, Your Honor. Thank you.
Okay.
Good afternoon, Your Honors. You're correct to focus on the fact that there was no reasonable excuse for the 18-month delay. We don't even need to reach the meritorious.
Well, what about counsel's point that it was caused essentially by mismanagement of not properly filing things or marking things? Why, I mean, there's office failure. Because
this is a persistent inaction. There's dilatory behavior here. I mean, we have a demand that was issued for this complaint on May 24th, 2017. The due date was June 13, 2017. That due date came and went, and they filed an affidavit of service, their office did, 2 days after the complaint was due. So at that point, they should have realized that a complaint was outstanding. Then you have the city making a demand on June 21st, 2017. And again, apparently they didn't calendar it or they missed it. And then they're supposed to serve it July 11th, 2017. And again, that date comes and goes. And then they don't even serve it until 2018, December of 2018, a year and a half after the second demand for that complaint was made. There's also absolutely going to be prejudice here. This incident happened in 2016. That's 5 years ago. There's also other issues that the plaintiff here brings up with respect to her health issues, for which she only...
Counsel, has the plaintiff stated a meritorious claim here?
She has not.
And why is
well, preliminarily, there's the statute of limitations bar a few of her claims. Those claims are assault, battery, unlawful eviction, and civil rights law 8. She doesn't address her negligence and civil rights claims, so those have been abandoned on appeal. And again, those other causes of action, which were false arrest and malicious prosecution, breach of contract, all of those don't even need to be reached because she didn't establish the reasonable excuse for the 18-month delay in filing of her complaint.
Okay, thank you, Ms. El Toro.
Thank you.
Let me hear from the other respondent.
Good afternoon, Your Honors. My name is Ellen Ravitch. I'm here on behalf of the city. As has already been discussed, there's no reasonable excuse here. The plaintiff makes the argument that any law office failure constitutes a reasonable excuse, but that is not the law. And while Supreme Court may have made a mistake in saying that law office failure can never be can never be an excuse for a delay. The mistake is not that any law office failure can be an excuse. The provision allowing for service of a summons with notice is really a savings provision for attorneys who are up against a statute of limitations and need to stop their clock from running. But it is not a license to simply sit on their laurels. And if you're making use of that procedure, you have to know that you are going to have to serve a complaint pretty soon. So this claim that the attorney reviewed 2 separate demands for a complaint, which had a 20-day turnaround, and then just simply forgot about it and now tries to blame some unnamed paralegal for not calendaring it, really is a terrible excuse, because if his complaint was due less than 3 weeks after receiving the first demand, it's impossible to imagine how he could have just forgotten about the case, which kind of makes the excuse and the claim that he reviewed these 2 separate demands questionable. But in any case, he can't completely shirk his duty and blame a paralegal for his own failure. He's the attorney. He had a responsibility. And he makes a general claim here that, oh, it's an isolated incident, and I continued to work on the case for 18 months. But the record really shows otherwise. First of all, it's not isolated because there were 2 demands served. He claims he reviewed both of them and failed with regard to both of them. But in addition, there's no indication that anything else was ever done. This is not a case where a conference was miscalendared, but the attorney was making motions and conducting discovery. There was nothing that happened here. And frankly, it's really difficult to imagine what could have happened in this case where a complaint had never even been drafted. And he claims that he did not draft it until the lateness came to his attention. In addition, the offered excuse becomes very unconvincing because there are 2 other excuses that make no sense when viewed with it. So they name both the plaintiff's illness and her Florida residency as somehow causing the delay. But there's no claim by the attorney that he had difficulty communicating with his client. It's clear that he just forgot about the case. And the client doesn't claim how her Florida residency or her illness interfered with her ability to communicate, including that there's no medical affidavit and no explanation how living in Florida could have kept her, for example, from using a telephone or anything else.
Okay, thank you, Ms. Ravitch.
Okay, thank you very much.
Okay, Ms. Bryan, you get 1 minute in rebuttal.
Sure, Your Honor. Just 2 things very quickly. First, I would just again stress the strong public policy in favor of resolving cases on their merits and urge this court that the plaintiff's case should be heard on its merits and not reduced to a technicality where what we argue a reasonable excuse has been proffered. And further, I would urge Your Honors to look at other precedent from this court regarding very factually similar cases in which law office failure in a similar manner was determined to be a reasonable excuse. Hertz Vehicles, matter of Rivera. These are cases where counsel's explanation was simply a failure to timely file due to an error in a case management system or a failure to regularly check their emails. These are all akin to textbook cases of law office failure, which is exactly what happened in this case. A failure between the handling paralegal and the attorney to calendar the case. So again, I would urge Your Honors to please have the plaintiff's case given the chance to be heard on its merits as opposed to being dismissed on a technicality.
Thank you, Ms. Bryan. Thank you all. Okay, next case on the calendar is Hammond versus Equinox. Appellant Hammond has 3 minutes.
May it please the court, my name is Neil Brickman of the Law Offices of Neil Brickman, and I represent the plaintiff appellant Steve Hammond on this appeal. Respectfully, we submit that the briefs that have been submitted in connection with this matter present a compelling case for why the trial court erred in dismissing on a pre-answer, pre-discovery motion to dismiss all 4 of Mr. Hammond's claims against Equinox. 1 for defamation, 1 for negligence, 1 for breach of contract, and 1 for intentional infliction of emotional distress. Given the limited time allocated to me today, if the court please, I would like to
Counsel, can I ask you a question? This is Justice Moulton. Is there a tension in the complaint in that you describe Mr. Alexander's remarks concerning the alleged behavior of Mr. Hammond to be somehow in service of Mr. Alexander's interests as opposed to Equinox? And you still are trying to hold Equinox in the case because Mr. Alexander was, you say, acting within the scope of his authority as an employee. Is that a tension?
Your Honor, I think you're referring to the vicarious liability and
correct
claim, but the short answer to your question, Your Honor, is all the evidence in the record points to the fact that Mr. Alexander was acting as a front office attendant, that the only reason he was allegedly in the steam room was that he worked there and that he filled out a workers' compensation claim and an incident report as an employee.
But Counselor, I think that the point that my colleague is trying to get out is that wasn't the employee acting with personal motives and really not in the furtherance of the employer's business, based specifically on the allegation you made in the complaint?
Your Honor, the answer to that question is yes, but the important distinction and what I wanted to focus this court's attention on was not on the vicarious liability defamation claim, but on the direct defamation claim based on the words of Equinox.
So just for clarification, are you saying you're withdrawing that claim?
No, Your Honor, we're not. We believe the record indicates, notwithstanding the fact that Mr. Alexander may have been making these defamatory statements to set up a claim against both.
Because you used the word weaponize, so it's hard to see how somebody could be acting within the scope of their employment and yet weaponizing, these false allegations against the individual. That doesn't sound at all like he's acting within the scope of his to further his employee's business. But you're saying that you'd prefer to move on to defamation.
I had intended for the court to focus on the direct defamation claim.
Okay, so let's do that. I mean, you claim that there were all the statements made by Equinox employees, yet you don't say what the statements are in your complaint.
Your Honor, respectfully, I think we do. Could it have been worded more artfully? And that's why, at the very least, the trial court should have allowed us an opportunity to amend the complaint, which it did not. But specifically, and it's a number of comments made by Equinox and Equinox's employees to the press, to the prosecutors, and in impertinent remarks made in a legal filing, which amounted to, we terminated Mr. Hammond's membership because of the invocation of a zero tolerance policy contained in a House Rules pamphlet that was made available to all clients, including Mr. Hammond.
Were those statements you're saying were made by employees to their employer, to Equinox? Is that correct?
Your Honor.
Well, I think what you said was they were made to Equinox, they were made to the press, and they were made to the police. Is that right?
No, if I did, I misspoke, and I apologize, Your Honor. What we're focusing on is comments made to the press in the August 25th and September 1st articles in the New York Post, to the prosecutor's office, and in filings to the lower court by Equinox's attorneys,
Okay.
which we claim fall
I'm sorry,
within-
counsel, what were the words used to the press in this case that you're alleging were defamatory with
That-
respect to your client?
that Mr. Hammond's membership was terminated as a result of the invocation of a zero tolerance policy with respect to House rules against lewd behavior.
Okay. Thank you,
so-
Mr. Brickman. We've gone way over your 3 minutes.
I'm sorry, I appreciate the court's time. Stay safe and healthy.
Thank you. Okay, Feinberg versus Marathon Patent.
Good afternoon, Your Honor. I believe Mr. Amon did join the meeting.
I am on. Can you hear me?
We can hear you, Mr. Amon.
Good afternoon, Your Honors. My name is Thomas Hammond. I'm here for the plaintiff appellant. I'm with the law office of Thomas Hammond in New York City. My co-counsel, who I'd like to introduce, is Steve Otto from the Robbins LLP firm in San Diego. Mr. Otto will be arguing today.
Okay. Your application is granted, although I'll be remiss if I did not point out what my colleague, Justice Massarelli, always does. You could not have found a New York attorney to argue this case. Having said that, Mr. Otto, welcome to New York, albeit virtually.
Well, my family comes from New York, so if that
There
bodes
you
well,
go.
then,
There you go.
well, good afternoon, Your Honors, and may it please the court. I'm here asking this court to reverse the dismissal of plaintiff's complaint that was dismissed with prejudice, which eliminated their claims for violation of Section 11 and 12A2 of the Securities Act of 1933. We believe that
Mr. Otto, just to sort of set aside the issue of whether the court improperly applied a heightened standard to plaintiff's securities claims. You agree that that's not the, I mean, as I understand it, the standard in essence is a negligence standard.
that's correct. And we think that the trial court's application of the fraud standard, which permeates the entire opinion, was in error. And as a result, under notice pleading, the allegations that plaintiffs have made state causes of action.
Okay,
So let's
tell me,
assume, counsel, let's assume that a heightened pleading standard, for the purpose of my question, doesn't apply. Have you, in this case, sufficiently alleged violations of Section 11 and 12 of the Securities Act? And can you be specific to tell me how you've done that?
Certainly. I believe we have. We have alleged omissions and misrepresentations in the registration statement, which was a violation of Section 11, and also oral misrepresentations which violate 12A2. And specifically, the main omission, which is a violation both of Section 303 of the SEC Rule 5K and Section 503, which require the disclosure of trends and risks, was the fact that this company was in a downward spiral at the time of the offering.
But counsel, this Justice Moulton, as you know, your opponents say there are no such thing as a trend in this area. There's incredibly volatile stock because it's based on settlements that they get from these patent cases. And your own complaint on page 2122 of the amended complaint shows, reveals that. Now, that's candid of you, but it shows that there were losses throughout the history of the investment. third quarter of 2013, fourth quarter of 2014, second quarter of 2015, third quarter of 2016. There were losses, some of them rather steep.
No, I don't believe that
So in other
chart.
words, there's no trend here. Can you respond to that?
Yeah, no, there was a trend. The trend was a downward spiral because for, I believe it was 7 straight quarters, they had demonstrated at least 7-figure revenue.
But counsel, all you're doing is saying revenues drop. Don't you need more? Clearly, as my colleagues pointing out, revenues drop from the third to the fourth quarter and prior quarters. But that in itself is not sufficient, no?
Well, it is when this is literally a death spiral of the company. They had never experienced this kind of decrease in revenue at all during the existence of the company.
But hadn't they shown, I'm sorry, counsel, but I just want to move us along. Hadn't they shown increase in the very month before, and then these decreases? So hadn't it been the greatest increases in one month and then the unprecedented decrease in another?
Well, we believe that's the wrong comparison. You have to look at the 7 quarters of earnings where the revenue was in 7 figures, and then they go down to 43,000, and then they come back up to 176,000.
But I think you just said it. They came back up. You said they came back up. Okay, so it's going up, it's going down, it's going up, it's going down. So what is the indication that it's going down and staying down, and nothing can cause it to turn around? Did you provide anything that suggests that there was nothing else that could reverse this?
No, we don't. There's been no discovery taken. But I want to focus on specific.
But counsel, notice pleading. Okay, you're not held to a fraud standard particularity, but you still have to give some notice. So you have to say something, make some allegation with respect to why the revenues dropped. No. Yeah,
well, the business was failing, and that's what we say. You can tell.
But businesses fail every day. Every day, and that in itself is not a violation of the Securities Act, no?
It is a violation of the Securities Act if during an offering, while the company is failing, you don't explain to the potential investors that the stock that they're investing in is most likely worth less than they're paying for it because they're not able to monetize their patent portfolio.
Okay, so tell me, so you claiming that that's the material omission?
Correct, that the company was experiencing a diminishing ability to monetize their patent portfolio. That was the trend that was not disclosed. That was the risk that was not disclosed.
Okay. Thank you. Let me hear from who's going first. Marathon?
Your Honor, this is Meredith Sherman with respondents Marathon Patent Group and Douglas Croxall, and I would like to respectfully ask permission for my colleague Howard Prevett from California to participate in the appeal.
Wow, again, no one in New York to handle this, huh?
Well, the case was brought first in California, I think.
Mr. Prevett, you welcome to New York.
Thank you, Your Honor. I wish I was there in person today. I am representing both Marathon Patent Group and Doug Croxall in this matter. What I would like to do is focus on several matters that were raised in the plaintiff's reply. And in particular, one of the things that hasn't been discussed yet is there's another set of claims called the holder claims that are also in this complaint. And as set forth in our papers, New York law bars holder claims. The plaintiffs are saying that California law should apply. And in their opening brief, they cited one California case, a California Supreme Court case, which we explained in our papers why that actually does not support their case at all. In the reply, they cited another case, a new case, Hussain versus Quality Systems. And there are at least 2 major reasons why this case cannot help the plaintiffs and appellants here. First off, this is an unreported California Court of Appeal case, and California Rule of Court 8.1115A is very clear that an unpublished opinion of the California Court of Appeal, quote, must not be cited or relied on by a court or a party in any other action. So quite frankly, this case they cite cannot be used for precedential value. However, even if you read this case, it supports the position that we have taken, which is that the plaintiffs have failed to plead the kind of facts they need to plead to show a holder case under California law. And that is to plead the element of reliance, and this is a pleading standard, they have to plead objective external facts beyond just saying that we were planning to sell our stock or thinking of selling our stock. They need to plead facts demonstrating that concrete steps have been taken to execute on plans to sell, such as about communications with brokers, written plans, number of shares, timing, etc.
Yeah.
In this same case,
court, has the first department, assuming New York law apply, have we taken a position on this, on holder claims?
yes, absolutely, Your Honor. I believe yes.
We say that they violate the out-of-pocket rule governing damages, right? Recovery by fraud, and are not actionable.
Correct. And as a matter of law, and I think actually the best citation for the first department case law is the Star Foundation case that we cited in our brief. It explains in fairly great detail why this is the law. And I would also point out that under California law, the California Supreme Court only focused on the issue of reliance because that was the issue that had been raised by the parties in that case. It's been noted by other courts, including the Seventh Circuit, which is in accord with New York, that the California case, for whatever reason, did not address the damages and causation issue. So that is still an open issue, even in California, as to how California court would rule on that point.
I'm sorry to interrupt you, but going backwards, can you address your adversary's arguments with respect to sections 11 and 12 of the securities law, and specifically with respect to, I mean, the known fact that there was a drop in revenue? Is that sufficient in itself to show a quote unquote known trend?
No, Your Honor. There was no trend here for a lot of the same reasons that the court was discussing with my adversary. What was known, and you're correct, what needs to be focused on is what facts were pled as to what was known at the time of the offering. What was known at the time of the offering was that the third quarter had not been a great quarter, that revenues had declined. That had been fully disclosed. And in fact, the third quarter information had been incorporated by reference into the offering documents. And it very clearly said that our revenues had declined for that quarter. It explained why, that there had been no settlements in that quarter. But it also talked about how we expect that there can be variability. The variability may continue in our revenues, but also pointed out that there were 20 plus existing litigation matters that were active at that time. And this is in mid-November of 2016. And that doesn't even take into account pre-litigation demands and negotiations as well. So that's what was known. With respect to the fourth quarter, really nothing could be known until the end of the quarter because these are settlements. As we all know, we're lawyers and judges, a settlement can happen in a day. So it would be impossible to know what would happen in a particular quarter until you get to the end of the day, end of the quarter. And in fact, one of the things that was interesting in the complaint is that they cite a quote that they attribute to Mr. Croxall on November 16th of 2016. So this is just within days before the offering. And he is commenting on the third quarter. And this is in paragraph 43 of their complaint, page 92 of the record, where he explained that and he was referring to the third quarter at that time, but it's just as attributable to the fourth quarter. He said, while potential revenue events existed in this quarter, we refused to materially compromise what we believe to be reasonable royalty rates in an effort to impact results in a particular quarter. So the point being is, they even cite an explanation by Mr. Croxall that at any given time, we're talking about trying to resolve these various different claims and litigations that we have, but we're not going to just settle a case just to make a quarter look good. But the point being is they present no facts that as of the time of the offering as to what they possibly could have known, the company possibly could have known what would happen a month in the future. So there's no trend here. The risks attendant to this business model were fully disclosed in the offering documents. And in fact, the history of the company had shown this up and down nature. And so there was no trend. There's no connection between quarters where you can show that something happened in quarter 3 that would carry forward into quarter 4 or even beyond, which is really what they would need to show in this case. There's nothing like that. It's just the fact of the matter is there were no settlements in Q3, and as of the time of the offering, it was still unknown what was going to happen in the fourth quarter.
Okay, thank you, Mr. Prevett. Okay, respondent Nuttall. I'm sorry if I mispronounced the name.
Actually, Your Honor, I think it's Greg Starner on behalf of the other defendant in that the Feinberg matter.
Okay.
Good afternoon, Your Honor. May it please the court, Greg Starner of White & Case on behalf of defendant Francis Nuttall. I'm happy to say I am in New York, but I wanted to just raise, I think, 2 particular points for the court. One, really I wanted to emphasize that with respect to our client, there's only 1 paragraph in the complaint that alleges any specific alleged statements by Mr. Nuttall. And all the statements are forward-looking statements about projected financial performance of the company looking forward. And they're all opinion statements that are protected by the safe harbor. But I wanted to touch on the common law fraud claims quickly and then turn to the security claims. On the common law fraud claims, I think you've heard about how those are holder claims. And another case I would refer the court to is the First Department's case in 2017. That's Varga v. McGraw, which I believe maybe Justice Augusta you were referring to. But yeah. So under New York law, these claims don't work. And I think as my colleague articulated, even under California law, they have not alleged sufficient facts and reliance to make out a claim. But in addition to that, and this is another thing we briefed in the trial court, but ultimately the court did not reach, at least as to Mr. Nuttall, these claims fail as a matter of law because the plaintiffs are alleging that they relied upon alleged misstatements for potentially or purportedly not selling shares in mid-2016. However, the only allegations against Mr. Nuttall are from December 2016. So as a matter of law and as a matter of kind of just temporal logic, the plaintiffs could not have relied upon any alleged statements by my client that were made months after they allegedly relied upon misstatements for purportedly not selling their shares. What's interesting is this is an issue we raised in the trial court. The trial court did not need to reach it. We also raised it here with this court in our papers, but it was not addressed by plaintiffs in their reply papers, effectively conceding that this is a fatal deficiency in their common law fraud claims as against Mr. Nuttall. So I'll just briefly turn to the securities fraud claims. I think I wanted to be responsive to some questions that were raised about whether or not there was a trend. And I think my colleague addressed principally some of those questions and highlighted the disclosures. But I would highlight 2 other points that I think we flagged in our papers. One, we're talking about a very short period of time, and that there are a number of cases that make it clear when you're talking about revenue fluctuations over a period of a short period here, a matter of a few months or a few quarters, that's insufficient to establish a negative material trend. And it's notable that the cases we cite, there are a number of them from the Southern District principally. They were not addressed by the plaintiffs in their reply. The other point I would make here, it kind of goes to what was really lacking from the allegations. And this goes to what the plaintiffs were required to allege. Now, the plaintiffs try to argue that this is not a case about scienter. They don't need to show scienter under Section 11. Now, while that's true, if you're alleging an omission under Item 303, they still need to show the fact that the defendants had knowledge, that in fact they knew about the misstatements, and that there was some fact that they allegedly knew that would make those statements knowingly false. And that's what's lacking here.
Counsel, do you
wait.
agree that the heightened pleading standard should not be applied as to the securities claims?
I don't think so, Your Honor. I think we would certainly highlight there are a number of allegations in the complaint where they allege concealment, intentional actions, or.
But aren't those really statutory claims and negligence? They're referring to the statutes, no?
Your Honor, that's the idea that a plaintiff who merely quotes the statute, that doesn't rise to the level of sounding in fraud. You know, I get that. I think they did more here. They allege concealment. I think I would cite to paragraphs 86 and 88 of the complaint. However, I think what we would say is, frankly, the trial courts didn't really rely upon that. Under Section 11, he found disclosures. It wasn't a question about heightened pleading standards. He said, you know, basically there's no trend and that there were sufficient disclosures. And under Section 12, and under, as I just talked about, under the Section 11 piece, there is still a requirement, regardless of the pleading standard, there's still a requirement for the plaintiffs to allege facts that defendants knew about at the time they made their alleged misstatements.
Or should have known about.
Or should have known. Well, to that point, Your Honor, I think it's a good, excellent question I think you raised. The courts on this, and we cite to the cases Black Moss, Medina, and Henry Jume. Those are all, those are two Second Circuit cases and two Southern District cases and a Second Circuit case, Medina. But two of those cases did consider allegations where defendants were alleged to, they should have known about X. And here there is one allegation where they say, just by nature of their position, they should have known about some unidentified financial information. The courts in those cases found that was insufficient. You can't just say that a defendant just in a conclusory fashion should have known about X. You have to allege specific kind of facts that show they knew about it.
Right. Well, Black Moss talks about actual knowledge, so you're right. Actual knowledge of purported trends. So.
That, absolutely, Your Honor. But Medina, in that case, the court was considering an allegation where the defendants were in a position to know. And then in Henry Jume, the court there considered an allegation where defendants must have known. And in both those cases, the courts found those to be insufficient.
Okay. Thank you. Thank you, Ms. Starner.
Thank you, Your Honor.
Appellant has 2 minutes rebuttal.
Thank you, Your Honor. Very quickly, I want to revisit the issue of the trend. And if you look at the chart on page 21 and 22, you can see that in each of the, while there was volatility of the amount of revenues, there was a floor that the revenues never went below $1 million. I think after the second quarter, the lowest they ever went was 1.1 million. There was a 1.3 million. And in the quarters leading up to the offering, there were 7 million, 2 million, and then 34 million. And then in quarter three, 43,000. And in quarter four, 176,000. So it's the scope of the disparity between the revenue that really indicates the trend here. It's not like they were, you know, the chart looks like the rest of.
But counsel, this is Judge Singh. You know, I understand there was a dramatic drop, but don't you still have to allege some underlying cause known to the defendants with respect to why there was such a drop?
Well, we believe that by the time of the offering, the fourth quarter 2016 was 2/3 of the way through. There was only, I believe, a couple weeks left in it. So at the time that they were putting out the prospectus and seeking investors in the offering, they knew that the revenue in quarter four was going to be drastically less than what they reported in the past. I mean, it wound up only being 176,000, which, you know, is pales in comparison to just about every other quarter except the one previous. And the history bore out. I know hindsight is 2020, but the following quarter was low. And then by summer of 2017, they abandoned the business strategy altogether because it wasn't working. And we believe that we've alleged that there was enough knowledge at the time of the offering that things were in this downward spiral, that there should have been at least some sort of warning to the investors that they were having difficulty monetizing their patent portfolio. The last item I'll address is in quite a few of the arguments, they raise this issue of forward-looking statements and how they're not actionable, and in particular the oral statements. But as set forth in our brief, in order for a forward-looking statement not to be actionable, it has to be identified by the speaker as forward-looking, and it has to be accompanied by a statement saying that the actual results could differ. None of these, I guess, precautions that are attendant to forward-looking statements were accompanying the statements that these individuals made to my clients. And as a result of that, they are actionable, and they were violations of 12A2.
Okay. Thank you, Mr. Otto.
Thank you.
Thank you all. Chen versus Lockett.
Yes, good afternoon, Your Honor. I'm Nicholas Farnolo. I represent the appellant Zuping Chen in this matter. We are respectfully asking this court to reverse the February 6th, 2020 decision by the Supreme Court, which improperly granted dismissal at the defendant's request pursuant to a collateral estoppel motion.
What was the basis of that dismissal, Mr. Farnolo?
So the February 6, 2020 dismissal was for two reasons. One, for supposedly collateral estoppel and res judicata, which was incorrect. And second, ostensibly, because of a neglect to prosecute, which ties back to an original judgment from July 1st, 2019. Now, this is a case with two claims that were filed. The first was filed on March 13, 2014, which is index number 152-243-2014. That matter was dismissed against respondent Lockett on July 1st, 2019 for failure to enter a default pursuant to CPLR 3215C. Subsequently, plaintiff refiled the matter against Ms. Lockett. Ms. Chan refiled against Ms. Lockett refiled the matter pursuant to CPLR 205, the saving statute, because the Supreme Court dismissed the matter, not for neglect to prosecute, not on the merits, and not for a lack of personal jurisdiction.
But counsel, didn't the court lay out the pattern of conduct that constituted neglect in this case?
Well, Judge, there's 2 points on that matter. That general conduct that the court discusses in its July 1st, 2019 opinion does not rise to the level of neglect to prosecute. And second, the court expressly dismissed.
I thought the court said that basically your client took no action against the defendant. That was in the 2014 action.
So the court indicated that no action was taken for a year after the plaintiff made 2 motions for default, both of which were denied without prejudice. The first, August 8, 2016, denied for not containing an apartment number in the affidavit of service. And the second on March 6, 2017, which was denied for being returnable on a Sunday. After that, for more than a year, no further action was taken, and the court granted the defendant's request to dismiss for a lack of default judgment pursuant to 3215C on July 1, 2019, not because of any neglect to prosecute or inaction by the plaintiff.
However, what does that mean? I'm sorry, what does it mean when the judge says the plaintiff failed to take any proceedings against the defendant? And then the judge says the plaintiff continued litigation against another defendant, Chen only, but defendant wasn't involved in that action. I mean, how many different ways, that's already 2 different ways, but how many different ways does the court have to say it in order for it to be a neglect to prosecute?
I didn't mean to cut you off, Your Honor. I understand that, but again, there is a case out there, Assets Recovery 23rd v. Gasper, which is the one that I think is most on point to your question, which expressly states that a dismissal under 3215C is not an adjudication on the merits, unless it's expressly stated by the court. And the Supreme Court didn't do that in its July 1st, 2019 decision.
Well, the court did everything except say the magic word, right? There's no catechism that's required. The court is not required to say failure to prosecute, saying, you know, you took no action against the defendant. Isn't that sufficient?
It isn't, Judge. And again, there's 4 cases that agree with me. In most cases that have ruled on this issue have agreed that a dismissal pursuant to 3215C, which is distinct from 3216, which is the neglect to prosecute statute, is not a dismissal on the merits, and therefore allows a plaintiff to refile their action under CPLR 205A. And that's why the court had to actually attempt to correct its July 1st, 2019 ruling in its February 6th, 2020
I mean, does 3215C have a time period by which you need to move for judgment?
No. Well, it's 1 year.
It's 1 year, right?
Within 1 year, correct.
Did you move within 1 year?
It was attempted twice, Your Honor, and then nothing happened for a year. So the defendants got that default dismissal. However, they didn't ask for a neglect to prosecute dismissal. They didn't get it. And the court's attempt to correct that later was error. And that's really why we're asking this court to reverse the February 6, 2020 decision, because this case was correctly refiled under CPLR 205A. Had the court...
Thank you, Mr. Farnolo. Thank you. Your time has run out.
Thank you.
Unless you want to use up some of your rebuttal.
No, thank you, Your Honor.
Okay. Counsel?
Thank you, Your Honor. My name is Thomas Torto. I represent the respondents. It's our position that Judge Silvera's determination, namely that his prior order constituted a dismissal for neglect to prosecute, was a provident exercise of discretion in interpreting his own order. It's true in his prior order, the court did not use the phrase neglect to prosecute. However, the prior order did set forth facts, specific facts, which reflect specific conduct that reveals a general pattern of delay and neglect. There was the first order that denied the plaintiff's motion for a default because of a defective affidavit of service. There was a second order that denied the plaintiff's motion for a default because the motion was returnable on a Sunday and the plaintiff never gave notice to the defendant of when the motion had been adjourned. And I think most important here is Judge Silvera's pointing out that when the defendant made the motion to dismiss the first action, the 2014 action, in opposition, the plaintiffs did not set forth any reason to justify their delay. That delay is from April 21 of 2017 into 2019. There's no reason to explain this lengthy delay of not litigating the case against defendant Lockett. And that document, it's a NICEF document number 133, appears on the 2014 clerk's document list. The court can take judicial notice of it. The plaintiff never explained why there was all this delay and a failure to timely move to a default against defendant Lockett. In addition, Judge Silvera properly pointed out that during the same time period, the plaintiff actively prosecuted a case against the co-defendant. We submit that this is not a case where the plaintiff inadvertently failed to move for a default within the 1 year period. That's what this statute was designed to address and give the plaintiff a second chance to bring an action within a 6 month period. But wasn't designed whereas here, there's a pattern of general overall delay and neglect. The Court of Appeals in the Andrews case has said that the courts should defer to the trial judge's determination as to what his prior order meant, what he intended by it. And in this case, the facts support his determination. I think that's the key here, along with the plaintiff's failure to come forward with any explanation to justify their failure to timely move for a default. Unless the court has any questions, I'll rely on my brief.
I think we're good. Thank you, Mr. Toro. You get 1 minute, Mr. Farnolo?
Thank you, Your Honor. Just quickly, I would suggest to the court to read my three-sided cases, Wells Fargo's Bank versus Itani, Assets Recovery 23 v. Gasper, and U.S. Bank Trust v. Mooney Stevens, which discuss the interplay between CPLR 205A and CPLR 3215C. In rebuttal to counsel's comments, the Judge Chavarri, could have dismissed this matter pursuant to 3216 in July 2019. He did not. That is because the defendants did not even ask for this case to be dismissed pursuant to neglect to prosecute under 3216. And as to the reason for not moving, that question is relevant to the court on this issue. If I was appealing the default judgment, it may be, but here the only question is, was this case properly refiled under CPLR 205A? And I would submit that it was. Thank you.
Thank you, Mr. Farnolo. Thank you both. Okay, 191 Realty.
Good afternoon, Your Honors, and may it please the court. My name is Jerome Frierson, and I represent the appellant, Josefina Tejeda. Your Honors, the central question on this appeal is whether my client is the rent-regulated tenant of the subject apartment pursuant to the 2015 amendment to the Rent Stabilization Law, Section 26-511C14, which operates as a preferential rent exception to the high rent vacancy decontrol statute under RSL 26-504.2. The Housing Court answered this question in the affirmative, dismissed the proceeding, granted summary judgment in favor of my client. Appellate term reversed.
Counsel, the elephant in the room is shouldn't a statute that could have such profound retroactive effects say that it's retroactive?
So, yeah.
More clearly, I know you rely on the prior to vacancy language in the amended section 26.511C14. I know you rely on that, but shouldn't the statute be more clear before it's going to be applied retroactively? Because it could apply to quite a number of tenants between 2011 and 2015.
So, Your Honor, we addressed this in our papers, and the statute does refer to past dates. So the entire period that the statute is referring to is between 2011 and 2015. So the statute refers to past ascertainable dates, and I cited to case law that says.
But shouldn't the legislature have said that it intended to re-regulate those apartments, or some language that would that supports your position?
So, Your Honor, in the record on page 273, I do include language from the legislative summary where the legislature does state the purpose of the statute and says that it's to preserve affordable housing, and that the purpose of the statute is.
But it doesn't. But the question is whether it states that they intend to resuscitate apartments that have been decontrolled pursuant to luxury decontrol based on a prior rent act, right? As in this case.
So, right. So it does the language that I referenced in the record on page 273 does talk about abuses of landlords. So specifically, the reason why they would be with respect to preferential rents an exception is that. And this is also considered in the Music Ayala decision, which I've asked this court to adopt, which the lower court adopted.
Counselor, your argument sort of sounds like the argument made in Regina. I know you say Regina is not applicable, but the HSTPA was intended to keep affordable housing, et cetera, but yet. Court of Appeals declined to apply it retroactively. I mean, what's the difference?
So yes, Your Honor, our case is very distinguishable from the Regina case.
But the policy arguments you're making are the same, right? The policy argument is to protect the housing stock in the city.
So, Your Honor, the policy arguments, yes, are to protect the housing stock in the city. But here's what makes our case distinguishable with respect to the constitutional arguments or the constitutional holdings in Regina. So Regina held that there was no legislative justifiable legislative purpose in increasing rent overcharge damages or rent overcharge liability for landlords. But specifically, and I refer to this in my brief, and I'll quote this this is from Regina. The Court of Appeal says, likewise, to the degree that prospective application of certain provisions of the HSTPA is justified because the legislature concluded those provisions will act to preserve the stock of stabilized housing or moderate rents going forward, retroactive application of the amendments to increase the amount of overcharge judgment or create overcharge liability where none existed does not return apartments to rent stabilization. So the Regina Court specifically talks about return of apartments to rent regulation as a justifiable legislative purpose of the HSTPA versus increasing rent overcharge liability. So that's what distinguishes this statute from Part F of the HSTPA. Part F, increased landlord liability. This statute does nothing more than provide my client with a rent-regulated apartment. It does not at all involve monetary liability, increasing monetary liability for the landlord. So that's what significantly distinguishes our case. There's absolutely zero monetary liability that flows from my client being a rent-regulated tenant. And this court has repeatedly held, and so has the Court of Appeals and the United States Supreme Court, that rent regulation is constitutional. And so this rational legislative purpose of returning apartments to rent regulation, this rational legislative purpose of preventing landlord abuse and circumventing rent stabilization using preferential rent.
So even apartments that have been properly deregulated pursuant to the previous Rent Act.
Right. So I'm not saying that people who have already been evicted, now all of a sudden have a cause of action under this law.
But forget about people that have been evicted. I mean, if a landlord basically is following the 2011 statute or Rent Act, as in this case, right? I don't think, or are you disputing that the landlord here did everything proper when they deregulated the apartment in question here?
Yeah, so exactly. I'm saying that there was nothing unlawful initially about the deregulation of the apartment, but the legislature in 2015 changed the law. My client moved in the apartment in February. The law changed in June of 2015. Initially, my client was she signed a market rate lease, and this was an unregulated apartment, but the apartment was returned to rent stabilization. And the Regina decision says that returning apartments to rent stabilization is constitutionally permissible. So yes, I'm not arguing that the landlord engaged in any unlawful act when the apartment was originally deregulated.
Okay. So it's the import of the new statute and whether that apartment re-regulated the apartment in question.
Correct. It re-regulated the apartment in question. My client is a tenant, still is a tenant. She was in possession when the law changed, and the law changed in her favor, and it made her a rent-regulated tenant. All housing court judges writing on this issue have ruled in the outcome that we're seeking.
Okay. Thank you, Mr. Ferguson. Let me hear from the landlord.
Good afternoon, Your Honors. May it please the court, Maxwell Breed of Warshaw Burstein for the landlord respondent. So let's back up for a moment here. Just remember that this provision doesn't say what the appellant said it says. This is a provision about prospective regulation. It speaks to the future. The language is about prospective exclusion. There is in 2614 some ambiguity because you have subsequent to a rent amount and then a subsequent to vacancy and then prior to vacancy a few words later. That ambiguity is resolved by the companion ETPA provision, which doesn't have the prior to vacancy. And that's really critical here, because in order for a statute to have such a drastic retroactive effect, the statute would have to clearly articulate not only the basis for the retroactive effect and the effect itself, but it would have to leave no doubt, and that's what Regina stands for. And appellant makes the point.
So your adversary distinguishes Regina, and I think it's a compelling distinction he makes. Why should we look to Regina?
Well, I think that Regina is distinguishable because Regina actually dealt with the statute that provides for a retroactive effect. This one doesn't. So that means that the Regina standard simply cannot be met. And that's this business about Regina recognizing that providing affordable housing might be a legitimate legislative purpose is simply untrue, because that speaks to the prospective effect of Regina, not the retrospective effect of Regina, of HSDPA, I mean. And that's a critical distinction. But as I said, the analysis in Regina is the same analysis that applies here, because you have a remedial statute providing for rent regulation. And for it to have retroactive effect, it would have to meet the high standard that is enunciated in Regina. This doesn't do that because the statute doesn't even provide for any retroactive effect in the manner that appellant suggests. The only retroactive effect of the Rent Act of 2015 was to bring the statute back a few days because the Rent Act of 2011 had expired. The legislature made it clear that the only retroactive effect was that. It was this very small window of time, a few days. Nowhere does the Rent Act of 2015 say that every apartment that was deregulated under thus and such provision is somehow re-regulated and recaptured into rent regulation. In fact, HSDPA shows us that had the legislature wanted to do something like that, it would have left no room for doubt, because the cleanup bill, the legislature came back and said, just to be clear, we didn't re-regulate anything. And for something so drastic to have occurred, the legislature wouldn't have left any room for doubt. Now, if the legislature had done this, it would be unconstitutional because due process hasn't been satisfied. There were no legislative findings tied to this. There was no justification explaining why all of these deregulated units ought to be recaptured. And that too is critical here. You can't rely on either a general legislative memorandum to that extent, or even the general purposes of rent regulation. There would have to be, and Regina stands for this proposition, there would have to be a direct tie to this legislative action, namely the supposed re-regulation of all of these lawfully deregulated units. And this does have consequence. Even though this appellant is not seeking monetary damages, we're looking at a period of time, 2011 to 2015, when there would have been a great number of units that came out of rent regulation. Now, here we stand 6 years later, asking whether all of those deregulated units now should be treated as regulated. That would, were that to have been the case, that would expose a great many owners to a great deal of liability for their actions that were based upon then current law. They were adhering to the law. And not only were they adhering to the law, but they were adhering to DHCR policy. And DHCR has never come out and said anything other than during the time that the Rent Act of 2011 was in effect, that regulated units would be permanently deregulated. So this, again, for the court to adopt this misreading of the statute would be to accomplish judicial re-regulation. This isn't something that the legislature with that, unless your honors have any question, I will rely on my.
No, I think we're good. Okay.
Okay. So, your honors, the landlord's council is speculating about how many apartments this will impact. This is a small carve out. It is about preferential rents, preferential rent tenancies. So we don't know. We can't say this is thousands of apartments. And certainly, again, there is absolutely zero monetary liability that flows from this statute. Just rent regulation, and rent regulation is constitutional. The legislature
What about the landlord's argument that any re-regulation will be an unconstitutional taking because it deprives them of due process?
Okay, so that argument was raised by the landlord in the appellate term decision below, in the appellate term, which reversed housing court dismissed that argument, and this court should dismiss it as well. It is not unconstitutional. Rent regulation is not unconstitutional. It does not infringe upon any substantive due process rights that the landlord has. The legislature has state police powers, constitutional state police powers, to promote the general welfare of the people and to remedy societal harms, including the emergency housing crisis that exists in New York City, and to preserve affordable housing. And that's what they did in this. That's what they did with this statute. And so it is just not. It's simply not true to say it is not correct that there's some kind of substantive due process violation with the retroactive application of this statute. This case is not about the HSTPA. My arguments are not about the HSTPA. This is about pre-HSTPA law. This is about the Rent Act of 2015. So with the landlord's argument with respect to the HSTPA, it's not applicable here. Also, the court below, the appellate term, relied very heavily on the Altman case. And again, the Altman case is about the Rent Act of 1997. And the sole footnote in Altman says that that decision does not apply to the 2015 amendments. My client moved in this apartment in 2015. So the Altman decision, that the appellate term relied on, does not apply to this case and was wrongfully kind of like included in the court's analysis. This case is not similar to Altman in any way.
Thank you, Mr. Frierson. Thank you both.
Thanks.
People versus Johnson.
Good afternoon, Your Honors. I'm Benjamin Weiner from the Center for Appellate Litigation on behalf of appellant Ronnie Johnson. Mr. Johnson desperately needs treatment for the mental health and substance abuse issues that he's struggled with for nearly his entire life, rather than additional incarceration. And this court should reduce his sentence to the minimum of 5 years so that he can access that treatment as soon as
Mr.
possible.
Weiner, he has been previously incarcerated, right? I mean, he has 5 prior felony convictions.
Yes, Your Honor. Mr. Johnson is a drug addict, and he steals in order to support that habit. And he has done that again and again, nearly for his entire adult life. He's been incarcerated.
Why would it work now if it didn't work before?
That's precisely our point, Your Honor, that there's no reason to expect a 7-year term of incarceration versus a 5-year term of incarceration to remedy Mr. Johnson's underlying issues. In fact, it will only harm him at great cost to the state. But there is good reason in this record to think that when Mr. Johnson is released from prison, he will be able to take advantage of services that he's offered.
But why this time, if not on prior occasions, he was able to do it? I mean, what's the difference from prior times?
First and foremost, he's 61 years old now, Your Honor. He is aging out of his
But
past.
he was 57. He was 57, right, when he committed that crime spree.
That's true, Your Honor. But if you look at the actions that he took while he was incarcerated while he was awaiting his plea on Rikers Island, really an incredibly adverse environment, he took real concrete steps that demonstrate his commitment to his rehabilitation. He worked with 2 social workers on Rikers Island, both of whom wrote letters to the court expressing how extraordinary his commitment to his rehabilitation was and how dedicated he was to getting the services that he needs. He linked up
when he, in instances when he hasn't been incarcerated, did he ever seek any sort of drug rehabilitation services?
Yes, Your Honor. So the first time he really ever had any kind of treatment for his substance abuse issues was in 2006, which I'll point out was nearly 30 years after he started drinking daily at the age of 16. And it was an overwhelming experience for him. He was forced to confront his past in a serious way for the first time and experienced something of a break. He was actually hospitalized and diagnosed with major depressive disorder and was so disoriented that he was unable to complete the program. And I would also point out that in the time period leading up to the offense, he actually was on a better track. He was in group therapy at the Fortune Society. He had gotten an OSHA certificate, but that was really derailed, and his life was significantly.
Has he successfully completed any drug rehab program?
Not as far as I know, Your Honor. And I would point out, too, that the court below here refused to order a KSAT alcohol, drug and alcohol program in prison. So there's no reason to think that he's going to get that in prison. What he needs is to be released. And I point out that he participated in a FedCap program while he was on Rikers Island that entitles him to services upon his release. He really did take concrete steps to ensure that he's going to have what he needs when he is released this time. And my office is available to support him as well. He can work with our social worker, who is a reentry specialist. Again, this is a man who's going to be in his mid-60s. It's different than his mid-50s. He's trying to get his life on track. And the real question for the court here is, what will it look like after 7 years versus 5 years? It'll be worse. Unquestionably, it'll be worse. His prospects for rehabilitation will be hampered by an additional 2 years in prison. And almost definitionally, that is excessive. There's no reason why 7 years, as opposed to 5 years in this case, is going to do any more than warehouse him at tremendous cost to the state. And so this court should give him the opportunity after 5 years in prison, which is a substantial prison sentence, given that Mr. Johnson was not accused of engaging in any violent conduct, even though the burglary offenses that he was convicted of are classified as violent offenses. 5 years is a long time. It is absolutely sufficient to meet the needs of punishment, and it gives him the greatest chance at successful rehabilitation, something he has shown in the course of this case and in the record that he is ready for, that he absolutely can take advantage of, and that he is determined to take advantage of.
Thank you, Mr. President.
Thank you, Your Honor.
People?
Good afternoon, Your Honors. May it please the court. As an initial matter, defendant's valid appeal waiver bars his excessive sentence claim. But at any rate, the negotiated sentence was an appropriately measured sanction for defendant's conduct. For a string of 6 burglaries, the last of which was a residential burglary that was committed while the resident was asleep inside, the people originally offered 11 years in prison. Then, in light of the same factors defendant cites for a sentence reduction today, the sentence was negotiated down to 9 years, then 8 years, and ultimately the 7 years defendant received, which is just 2 years above the statutory minimum. Defendant benefited immensely from the plea agreement and doesn't cite any extraordinary circumstances that would justify a further reduction. And for those reasons, his sentence should not be disturbed on appeal.
Counselor, the 17 priors, what were the nature of the convictions? I mean, were they for burglaries? Was there violence involved in any of them?
They were for burglaries and other theft-related offenses. No violence was involved for the most recent, but I think it is important.
In the 17, was violence involved in any of them?
In the 17?
The 17 prior convictions.
I know there was an attempted robbery, but that was, I think, a decade ago. But most recently, violence was not a part of the most recent offenses. But I don't think the seriousness of the residential burglary should be downplayed. The fact that it happened inside a residence certainly increased the chance of a violent encounter.
But it wasn't. What do you know? What about the burglary, the robbery? Do you know? The attempted robbery.
The attempted robbery, I know that was a conviction back in 1986, and he was facing 18 to 54 months.
And was it attempted? Is what? Do you know the circumstances of it?
I do not. But I did.
And what about this person's? What about his drug addiction? And what do you know about that?
The factors defendant cites are upsetting, but they did have to still be balanced against the aggravating factors of the fact that, this is his 18th overall conviction, his 6th felony. And I think it is important to note that defendant started receiving treatment while his sentence was pending. Specifically, the pre-sentence report stated that defendant was receiving mental health services with the Department of Corrections bi-weekly and was taking medications. So defendant's position that it's unlikely that he'll be receiving treatment while incarcerated doesn't add up, because it seems that the Department of Corrections started giving him the treatment shortly after him being arrested, and the Department of Corrections does offer both substance abuse treatment and mental health treatment services.
Okay, thank you, Ms. Gorski.
Thank you.
Okay, Mr. Weiner, you get 1 minute.
Thank you, Your Honor. So the record discloses very little about Mr. Johnson's prior convictions, but if you look at page 4 of the pre-sentence report, you can see it's burglary, attempted robbery again back in 1983, but it's burglary. This is what Mr. Johnson does. He steals without allegations of violence in order to support his drug habit. He is a man in his 60s. He is extremely unlikely to engage in violence when he's released. And he's certainly not less likely to engage in violence after 7 years than 5 years. I would urge Your Honors to look at the resources in our brief. The status of mental health treatment and drug treatment in prisons is atrocious. There is no reason to think that he will receive adequate treatment in prison in this case, especially because the court denied him KSAT below. And warehousing.
I'm sorry, can you clarify that about what the court did with regard to KSAT? What?
Yes, Your Honor. So Mr. Johnson himself urged the court at sentencing to ask the order docs to give him KSAT, which is drug abuse treatment in prison. And the court said no, because it hadn't been part of the plea deal, reducing his chance that he's going to be able to access services in prison, really for no reason. There's no reason to think this would have blown up the plea deal or something like that.
Does requiring that treatment in prison lessen his time?
No, Your Honor. He wanted just because he was desperate to engage in treatment.
But I'm just asking you, does completion of the program lessen his time? Is that a possibility?
I'm not certain, Your Honor. I'm not certain.
How much time does he have left?
So currently his conditional release date would be September 12th, 2023, and his maximum expiration date would be September 12th, 2024. And if his sentence was reduced to the minimum, his new maximum expiration date would be September 12th, 2022, I believe. So he would still have some time remaining in his sentence in this long 5-year sentence, even at the minimum. As to the appeal waiver, I just will say briefly, the court misstated the scope of the waiver and implied that it would be a complete bar to the taking of an appeal. The court never said that Mr. Johnson could appeal despite the waiver, and what he told him was he was waiving the appeal, and unless waived, what an appeal is the right to appeal a criminal conviction and the right to be represented by a lawyer in that appeal. So the only way to understand that statement is if you appealed, you could bring this to a higher court and have a lawyer, but you're waiving it, and so you can't. And that is precisely the kind of language that the Court of Appeals condemned in Bisogno. So for those reasons, thank you, Your Honor.
Thank you both. James O versus Bronx Preparatory.
Good afternoon, Your Honors. Megan Siniskalki for Appellate, Bronx Preparatory Charter School. Your Honors, the Supreme Court erred below because it applied incorrect facts here that are pertinent to the issue of notice, and it erred in holding that the issue of proximate cause is one for the jury. With respect to notice, respondent incorrectly argues that she does not need to show that there was prior notice of the alleged conduct. And in doing so, she conflates the issue of the general supervision of a school.
Counselor, wasn't the defendant on notice of conduct occurring in unlocked classrooms? And there's a policy with respect to unlocked classrooms, no?
Thank you, Your Honor. This is yet again one of the exaggerations that respondent has made on the record. The record, in fact, is clear that there were no prior incidents of sexual misconduct in any classrooms whatsoever, nor that there were
what
any
about just any use? I think it was not just sexual misconduct. What about any use of the classrooms, the open classrooms by students without supervision?
Yes, Your Honor. The policy of the school is that there are to be no students without supervision. However, this general safety policy is not sufficient to impute notice on the school that there would be a sexual assault occurring in the classroom.
Well, but the underlying reason for the policy is the safety of the students, right? That's what this executive director testified about.
Yes, Your Honor. The purpose of the policy is for the safety of the students, but the purpose of the policy was not for the specific prevention of sexual assault. And the issue here is that respondent tries to use this general safety policy to impute notice of sexual misconduct, which New York courts have ruled that general safety concerns are not sufficient.
So in this instance,
I thought the director was also told that there had been a prior sexual encounter in an unlocked classroom prior to the rape in this underlying case, right?
Your Honor, to clarify, the testimony that is in the record states that although the executive director had heard from a middle school employee who was not an employee of the high school, that she was aware that there may have been sexual encounters between respondent and Mr. Simpson. She did not testify that these encounters occurred in classrooms. Nowhere in the testimony and in the record does it indicate when these incidents may have occurred or where they occurred on campus. Therefore,
I thought the testimony was that the sexual encounters had taken place in the classrooms, which obviously had to be open if they were not supervised by teachers, right?
Your Honor, again, this is a mischaracterization by the respondent in their briefs of the testimony of Mr. George in the record, and my brief points to the specific testimony in which it does not state that there were any sexual misconduct instances in classrooms at the school.
And you're not just talking about this plaintiff, you're talking in general, sexual encounters in general?
Yes, Your Honor, both with respect to this plaintiff and in general. There were no known prior sexual misconduct encounters in classrooms at the school or anywhere in the school for that matter.
Counsel, why does the notice have to be so specific? If they're locking the classrooms to protect the students, can't they anticipate possible sexual assault?
Your Honor, the court in Morand, as well as in a 2010 case, the Court of Appeals, in Brandy B versus Eden Central School District, which is also a sexual assault case, have made it clear that a general duty to supervise is distinguishable from protection against specific harm. And the duty to protect against a specific conduct beyond general supervision only arises when said conduct is foreseeable. These cases and subsequent First Department cases, time and time again, rely upon the prior conduct of the alleged assailant. And in this case,
I thought that the injuries have to be foreseeable and proximately related to the absence of adequate supervision. If the underlying policy is to keep the doors of the classrooms closed, and nevertheless the door is open, it is foreseeable that those students will enter the room and not be supervised, which is precisely the underlying reason for the policy. So it's almost like a circular argument you're making.
Your Honor, I would argue that the general policy for supervision does not impute the required notice that has been required by the courts time and time again. And with respect to the proximate cause, I'd love to quickly just mention that proximate cause, the unlocked classroom door merely furnished a condition for the alleged conduct to occur. The actual cause of respondents' injuries was the intervening criminal and unexpected act of Kevin Simpson.
Was it so unexpected? Because it's my understanding from the record that there was a culmination of several prior acts. So it's not just one act, no?
Your Honor, although respondent claims that there had been prior encounters between her and Mr. Simpson, she admitted at her deposition that she never told anyone from the school about these encounters. Therefore, it is undisputed that no one from the school knew of Mr. Simpson's dangerous propensities prior to this subject.
Yet the school is aware of prior sexual activity between the two. And the school also had assigned, Simpson, as I recall, is 19 years old, no?
Yes, Your Honor.
And the plaintiff is 15?
That's correct.
Okay, and Simpson, as a school employee, was also assigned to monitor Simpson and sign him out at school, no? So there it seems to me that the school is aware of something with respect to Simpson.
Your Honor, as reflected in the testimony from Mr. George, the only reason that there was someone who would check Mr. Simpson out each day is because they did not want to set an example for other students at the school that it was permissible to have a 5th year of their high school education. It's completely unrelated to any behavioral issues with Mr. Simpson. The record is clear that there are no prior behavioral.
Thank you, counsel.
Thank you.
Let me hear from Jane Doe.
Yes, good afternoon, Your Honors. My name is Patrick Gaddy. I have the honor to represent Jane Doe. I hope everyone is healthy. This department has been very vigilant in protecting students from the failure of schools to properly supervise. Indeed, in the defendant's appellate brief, not a single relevant First Department case is cited. In the reply brief, 3 cases are cited, 2 of which have no meaning whatsoever. And Emmanuel is very easily distinguishable. Plus, to be honest, the 2 dissenters in Emmanuel had the better argument. But that's a sudden, spontaneous push case, not something that obviously occurs over time. We should never forget, this is a 19-year-old adult and a 15-year-old child. I submit that in a motion for summary judgment, defendant has the burden of eliminating all material issues of fact, and that is simply not done here. The gentleman
Counsel, doesn't it have to be shown that the school that the school authorities had sufficiently specific knowledge or notice of the dangerous conduct which caused the injury so that they could act reasonably in anticipation of something like that? Or they could reasonably anticipate something like that.
Sure. Thank you, Your Honor. Certainly not on the issue of whether a prima facie case is established. Assuming a prima facie case were established, my position is on a negligent supervision case like is before the court, there is absolutely no requirement of specific notice provision, just as in when a landlord leaves a lock undone or broken, he doesn't have to know that someone's going to come in and do harm. He's already committed the negligence. Obviously, a student in a school acting in loco parentis has an even stronger obligation than a commercial landlord regarding the locking of places where students should not have access. I think Bell from the Court of Appeals in '97 is just impossible, no matter how well the facts fell out. And our position on the facts is they very clearly favor the plaintiff. But Bell wrote, Unanimous Court of Appeals. A fact finder could reasonably conclude that the very purpose of school supervision was to shield vulnerable school children from acts of violence. Okay, in Bell, there is no mention of any notice. In this court's cases, Logan, Garcia, Shante D, Kuhn, there is no mention of notice. The only time notice becomes an issue is when there is a sudden spontaneous act that even supervision could not have prevented. Although I would point out this department has held schools liable for when a student throws an object, for when a teacher steps out of a class momentarily or turns his or her back. So no, I do not think that notice is a required element of this action, but regardless, as your questions made clear, there's notice. At the very least, as constructive notice, this same girl, when she was 14, was attacked in a classroom. All right, the school needs to know what's going on there. They implemented this policy regarding locking doors for the safety of students. They negligently left this classroom open, and a 19-year-old man used it to rape a 15-year-old girl. And again, as the court said in Bell, the very purpose of supervision of children is to prevent violent acts. In Bell, there is absolutely no mention of any prior pre-existing knowledge. What, in the one case defendant does cite, it's a school bus case, and a student exposes himself. It's clearly not as horrible an event as happened to Ms. Doe in this case. In that case, a student exposed himself, but while the driver was on the bus. There was no claim in that case of negligent supervision. Notice came up solely as to whether they should have moved seats. In this case, the defendant has admitted this was an empty, unattended classroom, and the purpose of the classroom was being locked was to protect
Counselor,
students.
how do you respond to the argument that the unlocked classroom just created the condition as not a proximate cause of the assault?
Well, I mean, then that would mean every case involving a landlord who just negligently leaves the door unlocked also just creates the area where the accident could occur. It's not a tenable argument in a case like this. Could they leave the whole school deserted and, just say, well, we didn't have to give any supervision because, well, we just created an opportunity where things could occur. This is a school. The standard of duty to a child is in loco parentis. It is the highest standard under law, aside from strict liability. And it is shameful that they created the opportunity for this to happen. Obviously, they didn't commit the act, but that's with any criminal case. They didn't commit the act.
Thank you, Mr. Gotti.
Thank you very much. I'm sorry, got a little emotional.
No, that's fine. That's fine. Can you get 2 minutes rebuttal?
Thank you, Your Honor. I would just like to reiterate that it is not appellant's position that the in loco parentis duty is owed here. However, even with the in loco duty in parentis duty, there still must be prior notice to protect against an additional particular harm. I would like to address plaintiff's reference to the Bell case. This is a case in which students were at a park as part of a field trip, and a teacher allowed the student to leave the area of supervision and then left the park knowing that the student had not yet returned. This is completely distinguishable from the facts here, as are many of the other cases that respondents cite in their brief, in which a teacher consciously leaves students unsupervised or directs them to do something that leads to the incident.
But couldn't you make that argument here? Couldn't you make that argument here? You leave a a classroom unlocked, and conduct occurs in the classroom.
Your Honor, this is different here because respondent did not have an appointment to be at the classroom at that time. Tutoring, and I may mention for a class that she wasn't enrolled in, tutoring is never offered at lunchtime. It is only offered after school. No teacher was expecting respondent to be in the classroom, and therefore no teacher consciously left respondent unsupervised. I'd just like to end by briefly saying that respondent's public policy argument falls short here because New York courts have already balanced the interests of protecting students while also not imposing a policing function on schools that is onerous and imprudent by the creation of this very standard that requires foreseeability in order for liability to attach. It was the Court of Appeals in Moran that stated, quote, "Schools are not insurers of safety, however, for they cannot reasonably be expected to continuously supervise and control all movements and activities of students." Thus, respondent has failed to assert a public policy concern that warrants circumventing New York's long-standing law on a school's duty to supervise. Thank you.
Thank you both. Kareem?
Good afternoon, Your Honor. My name is Herbert Eisenberg. I represent Syed Aftab Kareem. Dr. Kareem was a neurosurgeon who sought privileges at Lincoln Hospital. The real issue in this case is whether the Supreme Court's imposition of a sanction was appropriate. I'd like to commence my argument.
Is that the only issue, counsel, that you're addressing? Is that your primary issue here?
That's correct, Your Honor. We have walked away from the underlying issue concerning the grant of privileges. We have the utmost respect for the court system and judicial processes. We have always sought to comport ourselves professionally, act in good faith, and we've never sought to misuse court processes for improper motives, to be vexatious or inappropriate. The motion that we made pursuant to CPLR 5015 was not in any way undertaken to harass or maliciously injure anybody. The question of whether we went to the wrong court is really what caused us to be here today, having been sanctioned by the Supreme Court. In this case, there was an appeal after pre-discovery summary judgment motion that was denied against respondents. They appealed immediately. There was no discovery, and the record was closed. While that summary judgment motion was being pending before this court, there was a case that we brought in federal court asserting discrimination. And as part of that case, we received discovery. That discovery was not part of the record before this court, and that discovery demonstrated to us sufficiently that each of the very bases upon which Dr. Karim was denied privileges was challenged and not true.
So Counselor, as I understand it, the error really was that you should have moved to renew, presumably, before the Supreme Court. Would you agree that was the error in this case?
Well, actually, we did move to renew before this court, Your Honor. And the problem...
Well, no, I'm asking, shouldn't you have moved to renew before Supreme Court? And even assuming that's an error, does that amount to frivolous conduct?
Well, having prevailed in the Supreme Court, the idea of renewal before this court is what the Supreme Court suggested we do at oral argument on this motion. We tried to get this information before the court, however, it wasn't part of the record, and we sought judicial notice to be taken of this information. And we then, after renewal was denied and leave to the Court of Appeals was denied, having had this discovery information, we felt that that could come back to the court, which would probably alter the decision with regard to the grant of summary judgment, which is what this court granted. And so we were not seeking to waste anybody's time. We were seeking to get justice for our client. And having moved in the Supreme Court, the goal wasn't to do anything other than have the opportunity to be heard, because we believe, looking at the facts in the light most favorable to the non-moving party, which was our client, there were questions of material fact and dispute. That's what we did. We also...
No, go ahead, Mr. Eisenberg. I'm sorry.
Thank you. We also sought guidance from the clerk's office of the Appellate Division as to where to go. And we were told that the 5015 motion needed to be brought in the Supreme Court. Hence, that's what we did. We also believe there is case law that supports our having done so, where there are several cases that talk about the original jurisdiction, the court of original jurisdiction may entertain a motion to renew or vacate a prior order or judgment even after an appellate court has rendered a decision on that order or judgment. The court...
And after the, just after the appellate, after our decision was rendered, that is where you went, to Supreme Court. Isn't that where you went?
That is absolutely true.
That's where you went.
Unfortunately, I need to point out that we did seek leave to appeal to the Court of Appeals, which was denied in the interim. But that is exactly what we did. We sought that this case be heard on the merits.
Thank you, Mr. Eisenberg. Let me hear from respondents.
Good afternoon, Your Honor. My name is Len Rosenberg. I'm from the law firm of Garfunkel Wild. I represent the respondents in this long-running case.
So, Mr. Rosenberg, what I hear is that the wrong procedural path to put the issue before the court was followed. Is that sanctionable?
Well, my response is that the issue of the motion being brought in the wrong court is not the only reason why this litigation and the motion in dogged pursuit of an objective that's been clearly ruled by the Court of Appeals that can't be had.
May I just ask something, just for clarification? The motion was brought before the Supreme Court.
Yes.
Where else should it have been brought?
It should never have been brought at all. My point is that this case.
So then, if there was a motion with new evidence, what was he supposed to? What were they supposed to do with that? If they believed they had new facts.
First of all, the new evidence was not new evidence.
Well, they thought it was. They believed it was. There was information that it was the opposite of what had gone before the board.
And all of that was presented to this court on the motion for re-argument the petitioner made. It's the same arguments, the same documents.
Yeah, but wait a minute, Counselor. A motion to re-argue, you cannot. It's only on the record that we have before us. I think I was on the prior panel. So this is allegedly new evidence. New evidence gotten in discovery in the federal action. Why isn't it appropriate for the plaintiff to attempt to get his day in court by presenting the evidence either to the Supreme Court or elsewhere?
It's
inappropriate just to add to that. I just would like to add to that. This court can hear re-argument cases. This court does not hear anything regarding newly discovered evidence. We can only consider the record. So when you say that it was here on a motion to renew or whatever you said, we can't consider the other argument that information you're talking about.
My point is that at its core, this litigation arises under Public Health Law 2801B. That is the statute that applies to an alleged wrongful denial of hospital privileges. That is the action that petitioner brought. And the only judicial remedy is an injunctive action under 2801C. And the Court of Appeals in Fried v. Strassman said that standard of review is not for the court to hold a trial to determine the truth of the negative information. And that is petitioner's expressly stated goal from the very beginning of this case. So his dogged pursuit through all of these appeals and motions, besides the fact that the case law that he cites in support of his 5015A motion.
I don't know, counsel, it sounds like you're faulting him for having brought the motion before this court to re-argue. He brought it.
I am faulting him for pursuing a litigation with the expressed goal of getting a trial to determine the falsity of the negative information. The Court of Appeals says under 2801B, the court should not do that. It's a very limited standard of review, and we get into that several times in our brief. At every step of this litigation, petitioner's counsel has argued that his client, he just did it a few minutes ago, we're entitled for an opportunity to be heard. And what he has said over and over again is, my client is entitled to a hearing to prove that the statements that were made are false.
That's just semantic. I mean, the argument that they're making is that the new evidence showed that the ground for refusal was not objectively reasonable. And his claim is being made in good faith.
Well, the exact same arguments and exact same documents were presented to the Court of Appeals and to this court, and they're just simply being recycled and brought in.
I'm sorry to interrupt, counsel, but you're saying that the exact same arguments were made to this court, but this court could not consider that evidence. This court could only consider what had been in the record before us, originally on appeal. So where
If that's the case,
Where
then
were we
the
supposed
prior
to go?
motion was frivolous as well.
Okay. Thank you, Mr. Rosenberg. Mr. Eisenberg, you got 1 minute.
The only point I need to make is the question of whether the truth or falsity of their conduct isn't the issue, and we agree on that. But the good faith of defendant is the issue, and the only way to ascertain their good faith is an examination of whether or not they were actually functioning in the realm of truth or falsity. And we believe we were able to prove that. We don't think we should have been sanctioned for our efforts to do so.
Thank you. Thank you both.
Thank you very much.
Honors, stay healthy.
Salotaya.
May it please the court, Andrew Wanger for the plaintiff appellant. This is a simple backup case. The affidavit submitted in opposition to the summary judgment motion by the defendant driver essentially says that he looked but didn't see. And this excuse has been repeatedly rejected by not only this court, but also the Second Department. And another thing I want to highlight about his affidavit is that he claims he was looking in his backup camera as he was backing up. And he admits that he never saw the Durango that was right behind him until after the accident. And the question really is, how is that possible? And if he didn't see the Durango, it means he wasn't looking. And if he wasn't looking, then he's negligent as a matter of law. I think it's just that simple.
Counsel, is there any possible evidence or any evidence in the record that the driver of the Durango, Mr. Stesic, excuse me, was actually driving and was not outside the vehicle?
There is absolutely no evidence to that effect. Stesic says he was out of the car, and my client says that he was in the process of getting out of the car. There's no evidence that the car was in motion, though. The only evidence is that the car was stopped.
Counselor, why shouldn't we consider the city's VTL 1103 argument?
So I think there's really two reasons why VTL 1103 doesn't apply. And the first reason is that it requires that the vehicle is actively engaged in work on a highway. So you have a snow plow that's plowing snow. You have a street sweeper that's actually sweeping. Here, his affidavit doesn't say that. His affidavit says that he was on his way to begin work. He was planning on placing barrels. So he was at the time. So he was traveling to another location. So he wasn't actively engaged in the work at all, and there's no evidence he was. And the city doesn't even make an attempt to meet that criteria. The second aspect is, building on what I just said, also is that VTL 1103 doesn't apply to vehicles merely traveling to or from the work. And so his affidavit makes clear he was backing up to travel to another location to begin work. So for both of those reasons, 1103 simply doesn't apply. And really, it was incumbent on the city to lay bare all of their proof to support that 1103 claim. And they never even attempted to support it at all to Supreme Court. There's no mention of
it. They didn't raise it in Supreme Court, did they?
No, they didn't. And so they were required to lay bare all of their proof, and they simply failed to do so.
Okay. Thank you, counsel.
Good afternoon, Your Honors. May it please the court, Jonathan Popolo for the city defendants. First of all, this is, I think, is as clear as not a typical simple backup case. You have a working Department of Transportation truck that was legally permitted to be where it was and legally permitted to be doing what it was doing. It was, and you have a driver.
Just suggesting contributory negligence, that still wouldn't avoid the city being liable here, or the Department of Transportation being liable. I mean, that you were there legally, but the other car was illegally double parked behind you.
It goes to the reasonableness of the driver's actions. And I would like to sort of back up, I guess, for a second, Your Honor, and say that, I mean, we certainly don't agree that we're not entitled to the protections of VTL 1103. It was pled in the answer.
Isn't it correct that you raised those arguments for the first time in reply? I mean, can they really be considered at this point? Because don't they involve mixed questions of fact and law as to whether or not DeMarco was actively engaged in highway work, et cetera, et cetera?
That's partially correct, Your Honor. We did not raise it. It is accurate that we did not raise it in the response to the summary judgment motion that our adversary made below. It's not a question of raising.
Did you plead it as an affirmative defense?
We did. We did, and I think it is a mixed question, but you're talking about a situation here where, since their position is that you don't need discovery in this case, there's no way that they could have responded to it differently had it been raised in Supreme Court. So they're not prejudiced by that, and it simply goes to the extent that there's a question.
They prejudice in the sense that the issue was not made in Supreme Court, and therefore the judge did not have an opportunity to look at it and determine the factual, the mixed question. It's clearly not a pure legal issue, right?
Correct, Your Honor, but it's not a question where, like, they could have pointed to different facts in the record if they wanted to respond to it. They have the same opportunity here on appeal because their position is that they didn't need to go discovery. I mean, Supreme Court disagreed with that position. I mean, Supreme Court said that it's too early and I want to see more facts. And I mean, we're not sitting here arguing that you should grant summary judgment for the defendants on the VTL 1103 argument. We're just saying that it would be, unfair and improper in this case if the city, having pled that in the answer and that creating a different standard, was not allowed to go through discovery to see whether the facts support the application or not of that standard.
Okay. But what fact could be discovered to deal with the VTL 1211A issue that DeMarco should have taken adequate precautions?
Well, I think that DeMarco's affidavit, first of all, does detail all the adequate precautions that he took. And I mean, I think
was there a backup monitor in the vehicle?
There was a backup monitor. Their initial.
I don't understand. If there's a backup monitor, he's looking at the backup monitor. He's looking at the mirrors. How in the world could he hit a vehicle behind him?
Well, I mean, we don't necessarily concede that the vehicle was clearly behind him the entire time. I mean, if there are questions of fact that we haven't been able to probe the veracity of the driver of the other vehicles account and plaintiff's account.
Wouldn't all of that information be within the knowledge of the driver of the DOT vehicle?
No, so a lot of things wouldn't. I mean, whether the work zone was clearly marked, when did they pull up behind when did they claim they pulled up behind the DOT truck and parked? Was it immediately before they claimed?
But why does that matter? The fact is that Stesic was walking towards the car, right? So the fact that he's walking towards the car means the car is stopped.
But that's not what she says, though. There's a conflict in her testimony. She says that he's just getting out of the car when it happens.
So that still means the car is stopped, right?
I think that divergence creates the ability that we were entitled to challenge the veracity of their statements. And even if it's parked, it's still not a strict liability standard. Even under negligence, it's not a strict liability. It's not if you back into a parked car, you are strictly liable. It might create a rebuttable presumption of negligence, but you don't know where the car precisely was parked in relation to the truck. You don't know how long it had been there, whether the area was clearly marked as a work zone. There's so much that's not known in this case, especially given the specific context.
Well, didn't your client say the reason why he was there was to mark it as a work zone? So that hadn't been done yet. That was what he was about to do.
So he said he was there as part of a paving project. He'd been there for about, I think it was either 5 or 10 minutes. He claims the lights were activated. And at that point, he began to back up 10 feet so that he could be closer to the area where he was, so he could unload. I think they were road closure sort of barriers. So I think there's certainly someone could reasonably believe that is in the course of doing work, because you're there for a project. He's not traveling he has reached the area where the paving project is going to be conducted. He's reached that area and now he's backing up so he's closer to taking them off. It's not working, or at least certainly someone could there's a reasonable factual dispute as to whether he's engaged in work at that point in time.
Thank you, counsel.
Oh, okay. So I just want to address a few things that counsel just said. I mean, he basically just admitted that it's a mixed question, and therefore it was completely inappropriate to raise 1103 for the first time on appeal. And the other aspect is he's saying he's missing information about 1103, but that's information that the city has. The city should know what his own driver was doing. The driver himself should know that what he was doing. How hard would it have been for him to submit? Yes, I was actively engaged in work. I was paving the road. I was doing whatever at the time of the accident. He didn't say any of that, and so it's pretty obvious that he didn't meet the actively engaged in work requirement. The other issue about the motion being premature, all the issues that counsel has just brought up basically have no bearing on VTL 1211. The fact is the driver backed up, he didn't see the parked car, and he hit it. Everything else is just utterly immaterial. So the other fact I just want to bring up, because he mentioned where the cars impacted, is that the police report on 103 of the record identifies the impact areas, and it basically says the rear of the truck hit the front of the Durango, the dead center. So how he didn't see the Durango in the backup camera, I don't understand if he wasn't negligent. So that I'll rest on my papers.
Thank you. Thank you both.
Thank you.
All Republic versus Cornett.
Yes, good afternoon. Today we're seeking an answer to a simple question. Should an employer who does not own, operate, or control an elevator be able to be held liable for injuries that occur to their employee when that elevator malfunctions? We believe that this should not be the case. Two employees of Old Republic's named insured, Ferrier Construction, were injured while riding in an elevator at the Ravenswood Tunnel.
Counsel. We know the facts, but does Ferriera, I'm sorry if I've mispronounced the name, not know about the repeated instances where this elevator is malfunctioning?
Old Republic's position is that Ferriera knew that the elevator was inoperable at certain times in the past. There's no evidence whatsoever to suggest that at any time that equated to a dangerous elevator that could cause injury to individuals.
Is there at some point where, I mean, this wasn't just occasionally, it happened so often that there were occasions where they couldn't work for days, they could not do work. It was the only way to get down in this tunnel. I mean, there was a ladder, but that's not the best way. So, I mean, it's almost how many days does this have to be inoperable, or how many instances before it's an accident waiting to happen?
Well, essentially, Your Honor, the problem is that my named insured Ferrier was at the mercy of Con Ed. This was Con Ed's building, it's Con Ed's project, and Con Ed owned, operated, and maintained this elevator. It was even operated by a Con Ed employee. Ferrier's employees couldn't even operate it on their own. So there wasn't really an alternative of how to complete the contract without using this elevator. And the lower court did find that the ladder system was a suitable alternative, but Old Republic believes that that was an error, because it's clear that there were several days where they couldn't work, as you just mentioned, because the elevator was inoperable.
Well, I don't understand, Counsel. I don't understand why couldn't the ladders be used to access the work site?
Well, these are men who are doing construction, and they're going up and down repeatedly throughout. And it's clear from the testimony that they said that they couldn't manage to do it when the elevator wasn't working at certain periods.
Well,
at some points.
I mean, how big were the ladders? Were they just a normal 10, 12-foot ladder they had to go up and down, or was the distance much greater?
We don't actually know the answer to the exact amount of the ladder. None of the employees testified to that, but what they did say that it was a ladder system. It's not a stairwell. So it's a system of ladders is essentially what we know. And it was to get back and forth. This is a tunnel,
right? This is a tunnel.
I'm sorry?
This was a tunnel?
Yes.
A tunnel. Do you know how long the tunnel was? How deep the tunnel was?
I am not certain of any of that information, Your Honor.
Anyway,
But
counsel,
it
it sounds to me like you're arguing the merits of the underlying personal injury actions, and here we're just talking about, the duty to defend. So isn't there a reasonable possibility of coverage here?
Well, our position is that there isn't a reasonable possibility of coverage because there shouldn't be any circumstances under which an employer who has no control whatsoever over an elevator is found liable for injuries to their employees.
I don't think an employer can wash their hands of the situation like that. If they know that their employees are being sent to a dangerous instrumentality, they should do something about it.
But how do they know, Your Honor, how do they know that it's dangerous? I submit to you that the elevators...
If I know an elevator is malfunctioning a lot, I'm a little loath to get in that elevator.
Right.
Okay, maybe it hasn't stopped abruptly yet and hurt anybody yet, but it gives one pause.
And I thought it was known that the elevator was constantly malfunctioning. I thought that was part of the testimony here.
The record was that the elevator was down, not that it ever malfunctioned with anybody in it or that it ever caused an injury or a sudden drop. It's that it was not operable. I mean, you go to most courthouses.
Why wasn't it operable? Why wasn't it operable? Why was it down, as you say?
We don't have that information
was it down?
Because we didn't have any control over the elevator.
It's Con Ed's. You just said that Con Ed had control over the elevator, and Con Ed has hired your company to do the work. Sounds like they want to get that work done. So the elevator wouldn't just be down just because they wanted people to take the ladder that day, right? It had to be down because it was not functioning properly, right?
Your Honor, all I can say is, speaking as an attorney who's been in multiple courthouses throughout the New York City area, half those elevators are out every day, but we still ride them every day. Should a law firm be liable for their attorneys riding on the elevators of the courthouse? That's the question here. This elevator constantly broke down.
We're not in a tunnel. I don't know what the tunnel is like. There's a ladder, not a staircase with banisters, etc. I don't really see the comparison to be the same, but let's stick to these facts.
Okay. Well, under these facts, this was the way to get to the actual site. There also are no cases within the state of New York where an employer has been held liable for injuries sustained to their employees in an elevator that they did not have any control over.
But by finding that Ferreira is entitled to be defended, is not a finding of liability. We still need to figure out the underlying merits of the claim. What did Ferreira know? When did he know? When did he know it? When did Mr. Stout and Fasciano, what did they know about the elevator before they got in? All of this is stuff that will go to the underlying merits of the case. That's not what we're discussing now, is it? Sounds like you want to cut to the chase and deal with the merits of it.
Well, in order to be absolved of the duty to defend, which was over Public's motion for summary judgment, we do have to, essentially, the court does have to determine whether or not there's any possibility of liability against Ferreira. And based on the facts and the information here, it's over Public's position that there was no such duty.
With a reasonable possibility of coverage, right?
Yes.
Not liability.
Well, reasonable possibility. Well, it's a reasonable possibility of coverage based on whether or not there's any trigger of the additional insured endorsement, because it's not Ferreira that's looking for coverage here. It's Con Ed that's looking for coverage as an additional insured.
Right. Okay. Thank you.
I apologize. I was muted. Good afternoon, Your Honors, and may it please the court. My name is Laura Linneball of Wilder and Linneball, and I represent Consolidated Edison of New York. Just to address the court's questions before, The number of times that work had to be shut down was only 2 to 3, and the testimony of Mr. Stout was that he used that ladder system 45 times within 2 months. So it was a safe alternative. Con Edison asks that this court confirm the trial court's decision.
Counselor, how do you address your adversary's position that, hey, it's not our elevator. That's not our responsibility. What's your position on that?
Well, it's exactly as your honors had questioned Ms. McGuire, that yes, it is Con Ed's elevator, but Ferreira knew that that elevator had stopped working 30 to 35 times, that it malfunctioned, it stopped working, and yet they still sent their employees to ride that elevator. So there is a question of fact about whether or not there's a reasonable possibility that Ferreira's actions in knowing that sending their employees to a known defective elevator was a cause of this accident. The difference between I'd suggest too that comparing this to employers being responsible if their employees get injured in an elevator is a false comparison. This was a contractual agreement between Ferreira and Con Edison. And these are two very large, sophisticated parties. Ferreira is a company that has $400 million in annual sales and 1,000 employees. They were paid $4 million to install this pipeline, and in exchange for that money, they agreed to supervise this work site, supervise their employees working there, and to get insurance naming Con Edison as an additional insured. There are 3 reasons why Ferreira must defend Con Edison. First, Con Edison as an additional insured is entitled to the same protection as Ferreira, the named insured. That's under the seminal Court of Appeals case, BP air conditioning. Secondly, the duty to defend is exceedingly broad. If looking at the complaint and the facts known by the insurance company liberally construed, the claim arguably comes within the policy, the insurer must defend. That's under BP air conditioning and auto insurance versus Cook, another Court of Appeals case. The policy is basically litigation insurance. You're not going to be looking at a determination of liability. It's just, thirdly, whether or not there is a reasonable possibility that the accident was caused in whole or in part by Ferreira's failure to act. Here it was. They knew that this elevator wasn't working. They had ample notice of it. It broke down 30 to 35 times, and yet they still let their employees use it instead of using a safe ladder system.
Thank you, Ms. Linable.
Thank you, Your Honors.
Okay, you get 1 minute rebuttal.
Yes, Your Honor. Very quickly, it's just the simple thing too that should be pointed out is there's discussion that this elevator had shut down or not been operable 35 to 40 times. It was being run by a Con Ed employee, and yet it continued to happen that many times. And yet Con Ed, who has a non-delegable duty to keep their elevator, which they own and operate, in good repair, are trying to pass that liability along to their contractor.
But again, counsel, aren't you simply arguing the merits of the case? And maybe at trial, it could be that Con Ed would have a much more responsibility with respect to the defective elevator than you. We're just talking about coverage. That's all.
Yes, and it is Old Republic's position that that coverage should not include defense costs, because there's no scenario under which Ferreira should be held liable here, and that's what this all boils down to.
Thank you, Ms. McGuire. Thank you both.
Thank you.
Thank you.
People versus Fulmore Salvador.
Yes, good afternoon, Your Honors, and may it please the court, my name is Noelle Williams, and I represent appellant defendant Mr. Wellington Fulmore Salvador. We request that this court reverse the conviction for the 3 reasons discussed in our appeal brief, 2 of which I will discuss now. Mr. Fulmore Salvador was entitled to receive a mere presence charge, and the fact that he did not receive that charge constitutes reversible error. The charge was merited here because the standard requires that when viewed in the light favorable to the defense, a reasonable view of the evidence supported such a charge. That was the case here, and since the evidence presented at trial was insufficient to prove that Mr. Fulmore Salvador agreed to participate in a conspiracy, he should have received.
Ms. Williams, what are the facts supporting that charge? Absolutely.
So in this case, the primary evidence that the people put forth were 67 call transcripts that were read into evidence. This drug conspiracy, in the indictment, there were actually 9 individuals named, including Mr. Fulmore Salvador. Drugs were recovered in a bust, about 5 kilograms of heroin over 2 total busts. However, this evidence was gathered through these call transcripts that were intercepted. And there was never a warrant to intercept my client's calls. He was sort of caught up in all of this. My client—
How many times did your client appear on those calls?
Sure. So of the 67, he appears on 21 calls. But the thing you have to understand, Your Honor, is that my client had a relationship with the second man in charge in this.
Counsel, he's also mentioned, isn't he, separately from being on the call 10 additional times?
He is mentioned 10 additional times, Your Honor, but we
and
really—
didn't he live with Mr. Cruz as well as Mr. Mateo? I mean, at first he lived with Mr. Mateo, and then he moved in with the head of the organization, allegedly. So,
sure. Sorry, Your Honor.
How can he remain oblivious? You know, doesn't sound like mere presence.
Well, a few things, Your Honor. So my client came to New York from the Dominican Republic. He had a relationship with Mateo, who was the second in charge. They had a longstanding friendship from their childhood. And he'd worked in the Merchant Marines. He wanted to come to New York to get work. But when he arrived in New York, there was an issue with his documentation. So he moved in with Mateo, his friend, said, you can stay with me. And in exchange, he was cooking, he was cleaning, he was supporting the house. However,
aren't there facts? I don't think it's just the sheer number of times he's mentioned or how many times he's in the phone call, but isn't it the substance of what's said in the phone call that's significant? And is he not implicated by statements that are made?
Your Honor, I think the substance of the calls is important. However, the substance of the calls at best indicates mere presence or maybe even knowledge. However, in People v. Reyes, the court said that those elements, those alone are not enough to constitute an agreement, which is the actus reus and the key to a conspiracy charge. We're arguing that all of these calls might indicate that Mr. Fulmore Salvador knew about what was going on, that he was around it, but that is not enough.
So when he was arrested, his backpack had 3 phones, I think, money order forms. Money order forms, isn't that something that's used to launder money, drug money?
I'm sure it could be, Your Honor, but also I'm sure millions of people send money innocently to family, to friends. It's not necessarily indicative of drug behavior or being involved in money laundering.
That's for the jury, but the jury had those facts to evaluate, right?
The jury did have those.
To determine intent and to determine intent or infer intent from all of that evidence.
Yes, of course, Your Honor. But again, we're not arguing here that he didn't know or that he wasn't present, but that he didn't agree. And all of the calls, even the calls where he speaks, those are 21 transcripts. Of those 21 transcripts, arguably at least half are very innocent, running errands here, there, everywhere. No indication of drug involvement. The calls that are more questionable, even still, are not, I mean, there's nothing on any of those calls that very clearly links my client to drugs, where he says, yes, I'm going to take drugs here, or I'm going to, or I have heroin, or anything that would be very indicative of his knowledge and agreement. I think that's really the key here. I mean, he speaks on these calls, he clearly knows, but he doesn't necessarily agree. And all of this evidence is really why the charge was appropriate, because in the light viewed most favorably to my client, there is a reasonable view to support this charge that he was merely present. That charge. Sorry, Ron, I thought you were going to ask a question. Okay, thank you.
Your time ran out. Thank you so much. Okay, let me hear from the people.
Good afternoon, Your Honors. May it please the court, Rachel Bond for the people. The defendant.
So, counsel, it's clearly not just the volume, not just the number of times. What factual evidence is there that suggests that this defendant was not merely present at these occasions?
Sure, Your Honor. So there are, sorry, I'm just leaning over to get this. There are multiple phone calls where he is clearly participating actively in this conspiracy. So, for example, in People's Exhibit 9, which was a phone call from September 20th of 2012.
So you think using "we" implicates him?
I think that saying when someone asks, "How are you?" and he says, "We are not doing so well right now because 3 female cousins disappeared," I think that implicates him.
Can you just repeat that? I didn't hear that answer. You said.
This is actually from People's Exhibit 13, which was a few days later on September 24th, and an unidentified person asks the defendant how they're doing, and he says, "We are not doing so well because 3 female cousins disappeared from Rafa," which is what he often refers to Mateo as in these calls. And additionally,
and the 3 girls is not 3 young women, right? It's a reference to something else?
Correct. It's a reference to 3 kilos of heroin. It's apparently a very common code word to use for drugs, is to refer to a certain quantity of drugs as either girls or females, things like that. You can see elsewhere in the calls, they refer to the drugs as cousins or girls, women, light-skinned female, I think is another phrase that they use at some point. And in this call, in call number 9, or People's Exhibit number 9, Mateo actually tells defendant to throw out covers that are there to wrap you know what. And defendant just says, "Okay." And he says, "That's in the last luggage I brought," right? This is the defendant saying this. And then Mateo tells him to throw them all out. And he says, "Okay, perfect." So that to me also indicates that he's actively participating. He's throwing away something. This is also importantly the day after the 3 kilos of heroin were seized from the livery cab from Anna Nicotra in the Ottoman that were cut open. And additionally, then in that same call, Mateo tells him to take 2 packs of the small ones that are of 100. And the defendant just says, "Okay, no problem." So he knows what's going on, obviously, and the defendant is not saying that he doesn't now, although at trial he did. And that was part of why his account of events at trial lended no reasonable view of the evidence that would warrant a mere presence charge. It simply was incredible. He, for example, said he never saw an Ottoman because he was in the shower. Well, the Ottoman was in the apartment for 7 hours. So he didn't explain anything, essentially. He did not give a reasonable view of the evidence. And in any event, even if this court finds that there was a reasonable view of the evidence supporting a mere presence charge, the court's instructions specifically told the jury that they had to find that defendant intentionally agreed to enter this conspiracy and gave the expanded intent charge. And further, although it is not necessarily a substitute for jury instructions, the jury was presented with the argument of mere presence. It was discussed extensively in the defense's summation, and they clearly rejected that theory of the case. And so it is our perspective that there is simply no reasonable view. But even if there was, the trial court's instructions adequately conveyed that concept to the jury so that they would not rely solely on defendant's mere presence around these conspirators to find him guilty.
Okay, thank you, Ms. Bond.
Thank you.
Okay, Ms. Williams, you get 1 minute.
Sure. So just a couple of points that I'd like to address. I think the first point is whether or not these were drug references on these calls is not clear, but that was something for the jury to decide, and the jury needed the proper instruction to do so. Another point I want to bring up is it's not enough that the mere presence charge was addressed on summation. This court has said that before. This court has said that, quoting the Supreme Court, there's a difference between something discussed in a summation and an instruction from the judge on the law. And this judge even said, the trial court judge even said, I am the one who is instructing you on the law. So that instruction was really critical. There is enough evidence here for a view in favorable of the view most favorable to the defendant that the charge was appropriate and he should have received it. And this was reversible error.
Thank you, Ms. Williams. Thank you both. Ms. Williams, I'm having trouble with my computer, so I'm not accessing the brief. You working for Center for Appellate Litigation?
So I was an intern with the Center for Appellate Litigation while I was in law school. I was a 3L. I've since graduated and am now admitted, but I've appeared today as, of working with the Center for Appellate Litigation.
I hope you got admitted to the first department.
I did. I was admitted on January 11th in a similar Zoom situation.
Excellent. Well, welcome to the bar.
Thank you. Thank you for your time.
Thank you both. ISA Realty.
Yes, good afternoon, Your Honors. Ralph Prady of Kostadakis and Yakovu, attorneys for defendant appellant Lamar. Am I audible?
You are. I can hear you, Mr. Prady.
Your Honor, the court should reverse and grant summary judgment in favor of Lamar, in favor of the appellant, on the 3 counts in the complaint, which are breach of contract, unjust enrichment, and tortious interference. And additionally, the court should grant summary judgment in favor of appellant on its counterclaim for legal fees. Regarding breach of contract, Your Honors, there was no breach of the subject non-disclosure agreement because there was no confidential information. Nothing was designated by plaintiff in writing.
Well, are you saying in
verbally
writing, or what
as
about
confidential? Nothing, Your Honor, and that argument needed to be presented below to the trial court, and plaintiff failed to come forward with any admissible evidence regarding a verbal designation of confidentiality or proprietary, and since it failed to do that, it cannot now raise that on appeal. But nonetheless,
Counsel,
plaintiff came forward with nothing.
Counsel,
Yes, sir.
Was it your burden to state that there were no verbal designations as confidential? Did you carry that first burden?
Well, we did if it was our burden, Your Honor. But I must say, because we did raise the argument in our motion for summary judgment. I'm sorry, Your Honor?
Say that it is your burden and tell me how you carried it.
If it was our burden, we carried it by raising the issue and saying nothing was designated as confidential or proprietary. In fact, we go further by saying that nothing is even identified by the plaintiff as confidential information in the first instance. We really don't know if the plaintiff's talking about a sign opportunity on the front of the building, a sign opportunity on the side of the building, all of which we knew, by the way. We had a contract for a sign opportunity on the side of the building since 2008. And we developed concepts for sign opportunity on the front of the building, which is evidenced in our emails from 2009 and from 2015 to the landlord. So we knew about every kind of sign opportunity on the buildings, but we don't even know if we don't even get to that point because ISA Realty never identified what we violated. Go ahead. Yes, sir.
Counsel, before you get to that point, did you submit or were you required to submit an affidavit that plaintiff never verbally designated information as confidential or proprietary, particularly in light of the NDA that you had signed?
No, Your Honor. Our argument is that they don't even identify anything that was confidential or proprietary, let alone the manner in which it was designated. And if you look at the affidavits that were submitted in opposition, I submit, Your Honor, if there were verbal designations confidential information made by the plaintiff's staff. Well, they should have raised that
but wait
in
a
their
minute,
affidavit.
Counsel, I'm sorry for interrupting. This is Judge Singh. It's your motion for summary judgment. Don't you have the burden in the first instance to raise it? And then if it's not, if as you say, nothing is said in opposition, then you may prevail on that issue. But if you haven't raised it, why should the other side have to do anything more?
Well, I disagree that we didn't raise it, Your Honor. We said there's no confidential information. Now, no, and that begs the question, at that point, plaintiff, two things, Your Honor, should come forward as it's required and present credible evidence or admissible evidence of a issue of fact on whether or not something was designated.
You keep throwing the ball to their side, but it's your burden to establish entitlement as a matter of law.
No, Your Honor, that wasn't raised below at all. That's an issue that's raised on appeal for the first time, and it's wrong for appellant now, appellee, to inject that as part of 30 new factual theories that weren't raised below. And we itemized them in our reply brief, Your Honor, to the best of our ability within our page constraints. But more importantly, Your Honor, I mean, think about it this way. If a party thinks its confidential information was violated, it ought to know what that information is before it commences a lawsuit, and therefore come forward and say, which it never did.
What about the photos and the mock-ups?
Yeah, the photos and the mock-up none of them are designated at all as confidential or proprietary, and no argument was ever raised below in the affidavits submitted by Mr. Issa and Mr. Franco that they had been designated in any fashion, whether it was written or smoke signals or courier pigeon or Morse code. Or
I thought that your claim was that the documents were created by the Equinox Inc. and that therefore it was Equinox property.
Well, it is, Your Honor, and what's misleading was
the NDA, in reading the NDA, it doesn't require that plaintiff create the confidential information. It merely says confidential information means all confidential or proprietary information disclosed or made available by the disclosing party to the receiving party.
Right, but you have to look at the definition, Your Honor, of what confidential information is. It doesn't have to be created by
no, but they defined it. No. They defined it.
If I may, Your Honor, the definition is something that's designated as confidential or proprietary, and that's in paragraph 1 of the non-disclosure agreement. But this all begs the question for one very fundamental reason. We didn't even get to this, Your Honor. This argument shouldn't even be addressed by the court because we don't know what the confidential information is because plaintiff has never identified it. I mean, think about it. They have a lawsuit. They commence a lawsuit. They say we violated their confidential information, but they don't point to one piece of information. Forget about how it was designated, but they don't point to one piece of information that has been, that they say was confidential and that we used in violation of their agreement. They failed to point to one piece of information that they said was given to us.
I thought they pointed to the carve-outs on the 1D.
1D is
confidential.
No, that's our defense, Your Honor.
Let me finish, counsel.
Yes, sir.
As being within the definition of confidential information.
1D is our defense, Your Honor. To the extent 1D is a carve out, if you will, or an exclusion from confidential information. If it was developed by the receiving party, then it's not confidential. And we developed, or if we knew about it,
but they claiming that carve out, the existing design resembles plaintiff's design rather than yours.
Right. Well, first of all, that's a misleading argument, but we'll get to that in a second. The resemblance is phrased as exact match, if I may. And that's a standard which is not a standard because it doesn't invoke the contractually mandated standard, which is confidential information or proprietary information. And that's the standard in the contract that plaintiff drafted. So it's their contract. They said what the standard is, and nowhere is it found that exact match is a standard. In fact, exact match, Your Honors, isn't even a standard. It's an amorphous concept, which, since no one can figure out really what that means, it's no standard. But even if it were, it isn't the standard in the document that's required. So they haven't told us what the information
Let me hear
is.
from responding in this case, Counsel.
Okay, very good, Your Honor.
Good afternoon, Your Honor. Stephen Wegg of Kofsky Schwab, LLC, for the respondents. I'd like to just start with the easiest response to what my adversary just argued, which is whether there's anywhere in the record that what's confidential is identified. And it is identified on page 255 of the record in paragraphs 14, and it goes on to 15, where Joseph Issa discusses how the defendants are going through great stakes to differentiate the confidential renderings, which is exactly what Justice Acosta was referring to, how the renderings are not confidential. So that is addressed in the underlying motion, as is the concept of verbal designation of confidential information, which the plaintiff didn't raise at all. It's actually, because the plaintiff didn't raise it all, it's actually dropped in a footnote on page 281 of the record in footnote 3, where it's referred, where the motion papers discuss, or the opposition to the motion papers discuss, that the defendant did not address the ability to verbally designate something as confidential. And in fact, what the defendant did throughout the motion papers was refer to marking, using the word marking something as confidential. Now, marking requires it to be in writing, but the whole point is that there's the ability to verbally designate something as confidential. Going even beyond that, what Justice Crane—
Did you in this case designate anything verbally as confidential?
I'm sorry.
Was there a verbal designation made?
Yeah, it came out in depositions after the motion, because this was pre-deposition.
So there's nothing in the record before us that supports that position, correct?
What there is there's an email, which I believe is on page 189 of the record, which is a follow-up to a conversation and included the NDA, where it says, as per our conversation, and then it goes on to discuss how the deal is very sensitive and everything involved in the deal is very sensitive. And what Judge Crane found in the lower court is that, well, the definition of sensitive and what Mr. Franco was referring to as sensitive is something that really has to be fleshed out through depositions, and ultimately becomes a jury question.
Justice Moulton, you submitted 2 affidavits. Why not just have them, one of them or both of them, specify, yeah, this is what I said, and when I designated something as confidential? Why not do that?
The answer, I believe, is that the actual moving papers never even addressed verbal designations, and so it wasn't, in responding to what was before the court and the attempt to make a prima facie showing by the defendant, it wasn't actually something that was raised, and so it wasn't on the radar as something to respond to. Now, it would have been better, I agree, it would have been better had that been in an affidavit, but it not being there doesn't warrant reversal of the lower court.
It's hard to respond to the absence of something. You know, they're saying it doesn't exist, and then you don't bother to say, yes, it exists, here it is. It's hard to do much other than say doesn't exist.
It was, like I said, it was addressed in the actual motion papers, regardless of the affidavit. In the actual memorandum, it was addressed, and that how the defendant never once addressed verbal designation of confidential information. So it was definitely addressed, but there was nothing to say to it, because there's only affidavits from the defendant that say, well, nothing was ever designated in writing as confidential. Well, that according to the record, we do have where it's marked as sensitive, and how everything is sensitive, and the renderings, the extensive renderings. And if you look at page 324 of the record, you'll see that what was actually erected is, if not an exact match, in the very, very, very close match of the renderings that the plaintiff provided to the defendant and was ultimately erected after they were provided with the information from the plaintiff, and went behind the plaintiff.
Counselor, what area of the building did the landlord seek to lease for signage? There's some confusion in my mind. Is it just the left side, or also was it the southern side?
Well, it was both sides. In the past, there had been a sign on the south side, which is the side of the building, let's call it.
Which is the large rectangular sign is what you're referring to, right?
Which is the large rectangular side would be the side. But
so what's proprietary about that?
Well, that's not the issue as much in this case. That's more of the opportunity. The defendant had an opportunity in the past that ended. And then the plaintiff brought the defendant a new opportunity, which when it comes to real estate agents, a new opportunity even to a prior tenant is actionable. But if you look at the renderings that are throughout the record, 179 to 187, what's definitely brought to the landlord and was expressed to the defendant is the front of the building. And if
you talk about the left side, the left side, is that correct, sir? Left side of the building.
The front of the building. That would be the front of the building. Those renderings.
So the southern side is opportunity. Isn't that somewhat speculative that you would have had that opportunity on the southern side?
Well, we actually within the record, and I apologize, I don't have the page number in front of me, but in the record is actually a lease that was negotiated with the landlord for the southern side. For the southern side. So that it wasn't speculative because they had negotiated a lease, and not only that, Clear Channel put in an offer for that side. So once Lamar realized they weren't getting that opportunity, and that Clear Channel would, which is a competitor, they went behind the plaintiff's back and dealt directly with the landlord.
Thank you, Mr. Way.
None of that's part of the record. In fact, that's incorrect. We were solicited by the landlord. If we want to talk about record and what's not part of the record, we could talk about.
Sir, can you address just the questions I raised with respect to the front side and the southern side? Well, what's your position on that?
All right. The position is we knew about the opportunity beforehand, so it's carved out of the NDA, and that opportunity is with respect to the front of the building because we developed that concept in 2009 and 2015, which is evidenced by our emails, which are next to the motion and part of the record. On top of that, we also had that contract for the sign on the side of the building since 2008. So we knew about both opportunities.
Just be more precise. You're talking about the southern side, right?
The southern side, that's correct. The front side and the southern side were both concepts you knew about. With respect to information
that expired before the NDA? Didn't that expire before the NDA?
Yeah, but that's not relevant because it's the information that's protected in the NDA and carved out. So, Your Honor, if we knew it, which we did, that information is not protected. And that brings us back to the Daktronics photos, which were shared with us. They were shared with us. If they are indeed confidential, which they're not marked verbally, or there was no allegation that they were marked verbally as confidential or proprietary, and they aren't marked in writing as confidential proprietary. But either way, we knew about them before the NDA was signed because they were shared with us before the May 11th, 2017 date that the NDA was signed by Lamar, and they were shared in an email sent from ISA Realty on May 4th, 2017. That is found, the email is found at 179 of the record, and all of those Daktronic images were shared without the protection of an NDA, assuming they are confidential information, which they're not. And there's been no allegation in any context below that they were designated confidential in any form. And Your Honors, what this means is we moved for summary judgment after we met with a plaintiff regarding settlement. We exchanged documents, and we knew what we had been provided with by the plaintiff, and nothing was designated as confidential or proprietary. And it would be incumbent, I mean, any plaintiff that files a lawsuit, at least we hope in the state of New York, and says its information was confidential and that confidentiality was breached, ought to be able to come forward and point to that information and say with specificity what that information was. So in response to our summary judgment motion, plaintiff should have come forward and done exactly that and said, yes, this document was stamped confidential, or that document was marked verbally as confidential, and nothing to that of that kind was alleged.
Thank you, counsel. Thank you. Thank you both.
If I may add one point regarding a material issue of fact.
Counsel, you went way over your 2-minute rebuttal. You were up at 3 minutes, so I think we've heard enough on this case.
Thank you, Your Honors.
Thank you. Last is Barry's Boot Camp.
Thank you, Your Honors. Good afternoon. May it please the court, my name is Scott Kessler from the law firm of Ackerman LLP for the petitioner appellant Barry's Boot Camp NYC. We're here today concerning a BSA resolution that was dated May 21st, 2019, and then filed on September 5th of that year, which denied Barry's Boot Camp's application requesting a special use permit pursuant to sections 3231 and 7336 of the zoning resolution of the City of New York. This application was made to legalize the operation of a fitness center that's located on the portions of a ground floor and second floor of a 27-story mixed-use residential and commercial building in New York City on East 64th Street. We ask that the trial court's order dismissing appellant's Article 78 petition be reversed and that it annul and vacate the BSA resolution. On this appeal, we ask this court to decide whether the BSA's determination was affected by an error of law or was arbitrary and capricious or an abuse.
Is that the issue, counsel? Is that the issue? Isn't it a substantial evidence issue here?
Excuse me, Your Honor?
Isn't this a substantial evidence question?
Well, the question is what did the BSA act? Did they look at the facts or did they not?
Well, there were hearings here, right? There were hearings.
Yes.
So what I'm asking you is what's our review here? Is it straight Article 78 or is it substantial evidence?
Well, it's a straight Article 78 because the BSA here departed from their past precedent and procedure, and they did not look at the evidence that was submitted. Instead, they set a standard that there had to be an absolute satisfaction of two residents of the building that they not hear a single noise from the operation of the facility.
Counsel, this was after, I think you're talking about the fourth hearing or the fifth hearing. I mean, this was after years of an opportunity to correct this. This wasn't just a one and done that the board just looked and heard from you at one occasion.
Your Honor, you're correct. It wasn't just one hearing, but it was not over a period of years. And that's what differentiates this process from the previous two applications out of about 800 that were denied. This all took place over a 5-month period of time. So each time there was a hearing, Barry's, the appellant, went back and took the comments that they received very seriously and did substantial work to remediate these issues to make sure that the residents of the building that their issues were going to be addressed. Yes, I stand
corrected on that issue, but you were in the building for about 3 years, I think. You were in the building for a substantial time.
They were in the building since, I think, 2016, but there were no complaints that were issued until December of 2018 at the first hearing. So from 2018 until the denial in May, there were 5 hearings. The last 2 hearings weren't really hearings because the BSA had already communicated its intention to deny the application after the 3rd hearing. And at the 3rd hearing, when the residents testified, they had said that the work that Barry's has done so far has made the issue better, and we hope that they continue to make it better. So there was substantial progress that was made. And let me talk about the actual root issue, which is why the noise issues persisted. At the time the studio was being built, it was to be constructed as a box within a box. I'm not a construction expert, but from what I've read and what I've been told, this was to ensure that no noises escaped from the facility to any of the outlying areas. And so the work that was done, noise experts came in, sound technicians came in, we lowered the volume in the studio, we put down special tiles that are supposed to prevent the escape of sound.
Mr. Kessler, wasn't the point that, I mean, the dispute is not that you didn't do all of the things that you say you did to deal with the noise issue. The question is whether the issue itself is irremediable, whether it can ever be corrected.
Your Honor, I think the question isn't, it's whether what the studio, the facility brings to the community outweighs the disadvantages or the adverse effects that it brings. And there needs to be a balance. Not that everyone needs to be 1000% happy that we're there. And so the issue that was determined, and this was at the May 7th hearing, I think, and the city will correct me if I'm wrong, some of the BSA board members were architects. They raised the fact, well, this is still going on despite all the things that you're doing. Why don't we look at the structural issues? And they said this on May 7th. And so we said, okay, we don't think we have a problem because of our architectural plans, the way we constructed this facility. But we went ahead and we did that, and we hired experts to look at this. We discovered that there was a problem with the construction, and we were prepared to remedy that problem. But the BSA didn't care. Before we even presented our report showing our plans to fix the issue that the BSA asked us to look at, prior to that hearing, they sent an email saying, well, we got another complaint. We told you not one more complaint. We're shutting you down. We're sending you to the DOB for enforcement. Basically, we don't care what you're going to do. But we found the problem on May 14th. The BSA shut us down. On May 21st, we submitted a report saying, here's the problem. Let us fix it so we can resolve this issue. They didn't want to let us do it, and they denied the permit. Now, in other situations where there have been problems, they've allowed applicants 2 years to fix the problem. They expected us to do this in less than 5 months.
But I'm sorry, I don't understand. There were 5 hearings in this case. What occurred in those 5 hearings? I mean, there were complaints, there were attempts to abate, and you never abated. Isn't that sort of like the bottom line?
They were abated. They weren't eliminated. So there was a hearing in December, there was a hearing in February, there was a hearing in March, and then the final 2 hearings in May. Each time we took steps to try to fix the problem, and we were told that they did fix the problem. We sent in acoustical engineers to study the sound. Everything was compliant with the noise code.
But that's because it was in the afternoon, and they were talking about the first thing in the morning or late at night. Repeatedly, that's what they said, and that the acoustical experts couldn't really address what didn't exist at the time they were there.
We sent them in the morning as well. The only time the sounds were heard, you're right, is in the early morning and night when the ambient noise outside, because of probably a lack of traffic, is lower, so you can hear the noise from other places better. And I understand
that happens to also be the time people are sleeping. So that's the time you have to address, ambient noise or not.
It wasn't like 11 o'clock at night or midnight. It was 8 or 9 o'clock in the evening. I understand if there are children.
Right, it's also 5:30.
People want to rest.
Okay, let me hear from the city.
Thank you.
Good afternoon, Your Honors. Kevin Osowski on behalf of the respondents, Board of Standard and Appeals and DOB. It was not inherently irrational for the board to deny Barry's an unlimited
Counsel,
time.
let me just stop you for 1 second.
It was just
what
5 months.
Substantial.
Sorry, there were crossing questions there.
No, I think Justice Singh wants to raise the substantial evidence.
I just want to know what our standard of review is before you start your argument, because obviously you look at it differently. Is it arbitrary and capricious, or is it substantial evidence?
As my opposing counsel said, the one thing I'll agree with him on is that it is arbitrary and capricious review, and the board's decision here was not an irrational decision. It was well based in the evidence before the court, before the board.
So my question was going to be, and I'll still make it that it was 5 months and 5 hearings. Is that enough time to create a proper box within a box? Because I think everybody agrees that's what needed to happen. There needed to be insulation in the walls to avoid the transfer from speakers or whatever it is that was traveling up to the apartments. So was that enough time? Was that a fair amount of time?
So what the issue is here is that Barry's was operating without the permit, and that in order for it to get that permit, the board needed to find that it appropriately minimized the negative effects to its neighboring residents. And here, Barry's repeated attempts at remediation were unsuccessful, and nothing within the board's denial order prevents Barry's from fixing that structural issue and reapplying. In fact, one of the examples that Barry's relies on, the Equinox case, was a case where the board denied the special use permit. Equinox fixed the issue, reapplied, and the permit was granted. The fact that Barry's is operating and has been operating at that location since 2016 doesn't entitle Barry's to continue to disrupt the quiet and enjoyment of the neighboring residents while it tries to address this issue. And I think there's a lot of reliance placed on the structural engineer's report, and an examination of that report reveals that the report, yes, suggests that structural work is required before the issue could be fixed, but it also doesn't say that the initial structural solution, the erection of a new wall, would undeniably fix the issue. So it's the sort of the first step in figuring out whether there are other holes that need to be addressed before the noise issue could be addressed. And even then, the structural engineer can't say conclusively that the structural fixes would have resolved this issue and ended the noise complaints from the adjoining residents. The board heard testimony from the structural consultant before it reached its vote, and confirmed that what the structural consultant was saying about a structural issue and construction needed as remediation was the same thing that the board and Barry's discussed at that previous May 7th hearing. And at the end of the May 7th hearing, the board said, listen, it sounds like you have a structural issue here. You've tried to remediate through turning the sound down 1 or 2 dials, and residents are still hearing instructor voices and music. You need to stop the noise for 2 weeks between the May 7th hearing and the May 21st hearing, and Barry's continued operations as usual. And the logs and the emails between the residents and Barry's and between the residents and the BSA show that continued and persistent noise that the residents were experiencing early in the morning and well into the evening.
Okay, thank you.
Thank you, Your Honors.
Okay, Counsel, you get 2 minutes rebuttal.
Thank you, Your Honors. So counsel implicates that there was something wrong about Barry's operating from 2016 to 2018 without having the permit. There's nothing unusual about that. The way the PCE permit structure is set up in New York City, that this is what happens all the time, and we've submitted an affidavit to the lower court and to this court and in the record that it's normal for gyms like Barry's and Equinox and of the like to operate prior to getting approval.
I mean, I don't think that the city BSA meant anything by it. The question is whether you should get, or whether BSA should grant you the special permit in view of the ongoing and seemingly unfixable noise issue.
Well, I disagree that it's unfixable. We presented a plan to fix it. We were told on May 7th to do that. Barry's did that right away. But before the next hearing, we were told,
you fix it, you can reapply, right?
If we fix it, we can. I'm not certain that we can. I don't know that counsel's representation is 100% accurate. I'm not a zoning attorney by trade, so I don't want to give a definitive answer on that. But my understanding is that I'm not sure that that's right. The fact that the residents continued complaining after May 7th, those complaints were not shared with Barry's. They went directly to the BSA. They were not told, Barry's was not told about the complaints until it received the May 14th email telling them that we're denying your application prior to the May 21st hearing, and we're going to tell the DOB to enforce and shut you guys down. So there's not like there was a communication that we had noticed that there were complaints between May 7th and 21st.
But the point is, the overall point is that the noise complaints persisted, right?
The complaints persisted, but the question is if they were really, I mean, the residents knew if they made a single complaint, they were going to get what they wanted. And that's why this whole scenario was unfair, that the standard was that there cannot be one complaint, otherwise we're shutting you down. That's what the BSA chair said. That's not fair. That's completely arbitrary, and that doesn't follow the regulations. Thank you very much, Your Honor.
Thank you. Thank you both. Okay, so this ends today's session of the Appellate Division First Department. Good night.